Okay, let's go ahead and get started. I'm Alan Steinbrecher. I'm the chair of this working group, and this is a meeting of the California Attorney Practice Analysis Working Group. First of all, thank everyone first for being a member of this working group, and thank you for being here today. I think some of our members are attending from remotely. I think John Palmer's flight was canceled. So if there are any members of the committee who are attending by telephone, would you please let us know now? Go ahead and state your name so we know who we've got.
This is Emily Scivoletto with UCLA School of Law.
Thank you, Emily. Anyone else? Okay. Thanks very much.
Margie Estrada
has joined the conference.
Welcome, Margie. This is Alan Steinbrecher. We're just getting started.
Thank you.
Okay, just a couple of brief reminders. We are being webcast, so when you speak, if you do, please make sure that your microphone is on and that you speak into it and that you state your name so we have a recording of who is speaking and hopefully be able to capture what you're saying. Second, remember that this working group is doing its work under the Bagley-Keene statute regarding conversations and procedures and so forth. So our meetings have to be agendized and published and so forth 10 days in advance, but there are also some rules regarding communications among members of the working group on issues that are subject to the discussion of the group. I think there was an explanatory memorandum in the materials that were distributed last time. So if you are unfamiliar with those, please take a look. And if you don't have a copy, please let us know and we'll get you a copy. Okay. I just want to again welcome you and say that this is, of course, the second meeting. This is a meeting where we will start to roll up our sleeves and help form the questions and the of the survey that's going to be sent out in two different forms to practicing attorneys in California to inform ultimately whether the bar exam is testing the right things for the initial practice of law. So there'll be a lot more discussion and a lot more detail on all of that, but I just want to set the stage and welcome everyone to this working meeting, which will go from now until about 3 o'clock this afternoon. With that, I also want to ask Leah Wilson, the Executive Director of the Bar, if she has any comments.
No, I don't at this time, Alan, but thank you all for participating, and I look forward to a lively discussion today. Thank you.
The next item on our agenda is call for public comment. If there is anybody either here in the room or attending by telephone who would like to say anything to this committee before we begin our work, and now is the time to do that. Please speak up. I don't see anyone in the room.
Hi, this is Margie Estrada. I just want to clarify that I am just participating as a public participant today.
Okay. All righty. Thank you. Any comments from anybody attending by telephone who would like to address the committee or the working group? All right. Hearing none, we will go to the next item on the agenda, and I would like to introduce to all of you someone who you heard by telephone last meeting, but who is our consultant on this project, Jim Henderson from North Carolina. He has flown out here, and welcome, Jim. We thank you very much for being here and for helping us with this very important work. Let me now turn over the meeting to you.
Thank you all very much for being part of this process and for allowing us to work with you as we pull all of this together. I'd like to take a minute or two to preview the agenda with you this morning that we expect to use. At this time, we'll have an overview about practice analysis and the timeline for the project. And then we're going to have an orientation to the content framework that we expect to organize our conversations around. At 11 o'clock or sometime close to that, we'll break into two groups. One group will work with me in this room to make some decisions about what the content domains and performance domains should be in this outline. And then the other group will work with Josh McGinnis to my left and on the scales that will be used in the survey. After lunch, after a lunch break, we'll reconvene into those two groups and continue that until about 1:30, when we'll have reports from each of the groups so that everyone in the room is oriented to the decisions that were made in those groups and understands that rationale. And then we'll have some conversation about panel recruitment for the meeting that's scheduled for March 8th, 9th, and 10th in San Francisco. And then we'll wrap up the meeting at 3 o'clock. The practice analysis process and timeline, and I'd like to begin that discussion with a sort of a concept about what we're here to do today and what we're hopeful of coming away with at the end of the day. So, and I know I made this explanation in December, but I'd like just to give you a little refresher. A practice analysis study is really a giant job description of the responsibilities that attorneys have and the tasks that they perform in their work, and then also the knowledge that is required to perform in a proficient manner in the role. So the purpose statement that's at the top of this page, and I grant that the font is very small in the room, so you might prefer using the handout for this. It's an outline of professional activities or essential topics that make up the practice of law. And our focus in this is at the entry-level licensure of attorneys. And then once the outline has been validated, it will serve as the content framework for the bar examination. Now, what we are not doing here today is designing the test or changing the test in any way today. That is like those discussions will take place in the future after the practice analysis has been completed. Everybody has ideas about examinations. We've all taken them. We have all suffered through a certain amount of that. And probably we all have some sense of what we think the bar exam should be. Those opinions are going to come into play much later in the process. And I think that the soundest basis for the design of any examination is a practice analysis study. And so what we need to focus on here today is the description of the work that makes up lawyering and the knowledge that lawyers rely on in order to provide proficient service to the public. I'll just review the two phases of the project with you. The first is survey preparation. And as we discussed in December, the first box there, established domain framework. Really, that's what we are going to do today. And I believe that the work that we do today will will be very useful to the panel that meets 2 weeks from now. We'll get a small way into identifying tasks and subtopics today, but the ones that we develop will only be for the sake of example. The practice analysis panel will have the responsibility for the detail. And so that will work so what we're trying to do today then is decide on the content domains and the performance domains, and then develop some useful examples that members of the practice analysis panel can understand and use to develop a product that we will all be happy with. Once that outline, well, you're actually working today to select scales. And these are the means that people will use to give their opinion in a survey about the different domains and tasks and subtopics that we'll develop. And then we'll use the scales to design and build the online surveys. Again, there are 2 survey modalities that we expect to use. The first is a traditional practice analysis survey that will present the different domains, and participants in the survey will use the rating scales to evaluate the domains and tasks relative to their own practice as attorneys. It will also include a demographic set of questions that will allow us to do 2 things. First, to understand who it is that responded to the survey so that we can know that we got a good mix and a representative selection of people given the population of attorneys in the state. And then the other major purpose is to allow us to use variables that account for different aspects of practice that were collected in the demographic survey to do comparisons to make sure that the domain framework that we put together applies in a reasonably reliable way across practice settings and different and other dimensions. So that all is phase 1 in terms of the survey preparation. Once the survey has been designed and built and put online, go through an extensive QA process, and then we'll begin collecting data. So obviously that the ability to begin collecting data requires some decision making around the selection of participants and all of that, and that's not on the docket for this meeting, but for one coming up soon. So during the time of the survey, we'll monitor participation, we'll send reminders, and that will do a lot to build the response rate so that we can achieve to collect as much data as we can. The second survey modality is known as the experience sampling method. And the way that that's going to work is that members of that sample will be pinged at different times of the day, and they'll select the task that they were performing at the time of the ping. And it's going to, so it will be, you know, which task were you performing at 2:45 today? And they'll indicate that. And so it'll be a very frequent contact that those people will have with that experience sampling method survey. And it'll give us a really great insight into what actually is performed and how frequently we will see the different elements of practice. All of the data that's collected from the two survey modalities will then be compiled, analyzed, and brought back to the bar and to you, and we'll talk about how to make meaning from the information that is gathered there. And then we'll summarize it all in a final report. The timeline is at the bottom of this page or the slide that I'm displaying now. And you can see where we are at the second work group meeting, and then March 8th, 9th, 10th, well, it is 8, 9, and 10 that we will have the panel workshop meeting. And then that will give us the ability to build the surveys and to field test them with a beta survey, and then ultimately, once we have analyzed the results of the beta survey and know if we need to make changes in the design of the survey, we will get that done and launch the survey into August and collect data for several weeks. We'll generate the report and review the findings, and then the practice analysis should finish, we expect, in December. I'm happy, I've given you a lot, and I'm happy to take questions.
Hi, Jackie Gardina. And just a quick question so that I understand. One of the struggles that we have had when it comes to the bar exam is defining that minimal competence idea. I'm assuming one of the goals that will come out of the report is being able to better define what it means to be minimally competent to practice law so that we know what we're looking for in a successful bar exam taker.
It's on. It's on when the light's on. Thank you. Yes, the framework that we put together of domains and tasks and subtopics will describe the universe of knowledge and ability that is expected of attorneys. As we compare the responses of different groups from the surveys, we'll be able to identify people who are new in their careers and what they tell us they spend the most time doing. And that will go a long way toward informing us about the content framework. Ultimately, what this will become is a standard for entry-level knowledge and skill. So it's an important question, and I think it will be in black and white once that outline is put together. Are there other questions?
One more question. What is the necessary response rate to make the survey valid statistically?
The survey response rate is obviously really critical. But as important as the response rate is that we can document that we have representation from different practice settings and different ways that attorneys work, and different experience levels, all of the demographics of the field. And so from my view, just as important as the response rate is the composition of the responding group. Response rate is a judgment call made at the time, and generally we have seen And as a person who's done a whole lot of practice analysis studies, I have seen a decline in response rates over the past several years, probably because it's so easy for people to put surveys online that it's happening every day, and people get asked to participate in surveys to the point that they just don't have time for any anymore. And so we'll be very happy if we get, a 10% response rate. If it's lower than that, and it may well be lower than that, we'll have to assess the adequacy of the data that we do have to see where it goes. We used to get pretty reliably more than 25%. And in some professions, we can get much higher. One of the strategies that we have in mind to use to boost the response rate with this study is to send out communication to people who are licensed and ask if they would be willing to complete a survey. Give them information. If they say yes, give them information about when it's coming, what it will look like, and prepare them and remind them that they made a commitment to complete the survey. And so that will help boost it. And then incentives can be used as well to promote participation in the survey.
This is Robert Brody from LA. Donna, I know at the last meeting, had we talked about maybe offering MCLE credit as incentive, especially for the ones that are going to be providing responses? Because I think that's important, and I don't know, do we have any more to say? Is this the time to talk about how we can make sure that we get a full response?
Yeah, so that's exactly, ooh, that's loud. That is something that in fact we have talked about doing, providing an article that people who are participating in the survey would read to enable them to get credit, so we could combine the time it would take to read
Margie Estrada
has left the conference.
the time it would take to both read the article and do the survey for that credit. We didn't feel the survey alone would qualify under the existing rules. I've been talking with Sarah, and Sarah is going to assist us in the development of what that article might be. So we need to brainstorm along with her on coming up with an article that would qualify for the self-study, something that really looks at sort of the changing face of law in the past 20 years, right? Something like that sort of ties to the survey and the concept of what we're looking at the survey. But Sarah also indicated she's got a ready group of lawyers who would be willing to assist in the development of such an article.
Are there other questions about practice analysis, what it is, and the timeline and process?
Yes, Sarah Cassidy. So you mentioned that a 10% turnout rate on such a questionnaire would be pretty common, and I thought that number seemed particularly low, and I was wondering if you could tell us a little bit about whether or not we're going to be able to get accurate information from 10%, and then also a little bit about your firm's experience with doing practice analysis for other attorney groups, and whether that's like a number that's particular to attorney groups, because you mentioned some professions are more likely to have higher turnout rates. So if you could just talk a little bit about that, that would help. Thank you.
Very important questions. So the possibility of a low response rate it's the reason that I pay more attention to the demographic makeup. There are surveys of attorneys in the state that have described the population, and if we can tell from the demographic data, the participants in the survey, that it aligns not unreasonably with the demographic makeup of the field, then we can, I think, have real confidence that the data that we've collected is useful and good. So in terms of my firm's experience with attorney practice analysis, I have to say that there have been very few attorney practice analysis studies ever done. And so I think, so we have not had any. However, we have done practice analysis studies for physician specialties, for psychological specialties, for engineering and design organizations, and it's through those activities that we are able to talk about the general trends in the field. The number of studies in law has been fairly limited, and so I don't think anybody really has deep experience as a practice analyst with the legal profession.
If I may, Stephen Ferrollo, I'm thinking of my colleagues in firms where you have to account for every 10th of an hour. I think that's part of the problem with our profession. But I think you just stated an important point, which is these are rare. That's why this is so important. And I would ask the question of, or maybe just state that I think it's going to be very important on how we market and articulate the importance of this study and tell people how critical this is, not just on the issue of the bar exam, but really on the future of the legal profession in the state of California. I think we're at a critical juncture, and I think we need to, in advance of just sending out the survey and asking people to participate, is do a marketing campaign about how important this is and how critical this is, I think, to all of us in the legal profession here in California.
I agree, and I was just going to say, I think I'm not as concerned about participation as maybe others are, because we will have a very intentional and proactive communication strategy. We have a great infrastructure set up to communicate with almost all of the law firms in California who have signed up to do agency billing with us. So we have a mechanism to communicate with all of those firms. I think there is going to be a great deal of interest in the study. As Donna mentioned, we are working already to create an incentive for participation on the MCLE side. And I would just note that every 5 years we do send out a survey to all of our licensees, all attorneys in California. For the last one, we had a 17% response rate, and it was a very lengthy survey. So given the numbers that we have here in this state, my understanding is that is sort of a sufficient sample size for representativeness. So I think all of those things combined make me feel pretty comfortable that having enough people participating is not going to be a concern.
Thank you, Leah, for that. Jackie Gardina again. I think where my concern lies is not necessarily the whole number, 17% of all licensees, but rather will those in a not-for-profit setting or a public defender setting who are overwhelmed with work put it to the side. And so getting a sample across the broad range of different types of practice, I think, is a bigger concern, and it sounds like it's a necessary component. And so how can we create incentives beyond even the marketing to help those solo practitioners and others to participate in it as well?
The sampling strategy is still on the table and will be decided at some point in the future. But the one thing that we can do is oversample in areas that are relatively small, so that we can make sure that we get good representation from those areas.
This is Rambi. I can confirm with Jim's strategy about oversampling being part of the weighting scheme that we could look at the representation of different practices or geographical areas. As long as we have underlying information about the overall attorney population, then adjusting the weights for different groups is always part of sampling strategy, and then post-survey analysis, so that you know at the end, after adjusting with the appropriate weight, the overall representation of the attorney population is accurately reflected in the sample that you actually have. But that relies on a sufficiently large response, not necessarily dependent on the response rate because we have a large population. Typically, if you have a few thousand, it will allow you to make all of those adjustments to get better representation.
So then are there other questions before we move on?
I don't have a question. I have a comment to make, and it's just a timely comment about how we could use this wonderful document that the town helped us make in the CAPA process and timeline. Because as you can see here, the survey distribution strategy is going to be occurring and starting in phase 2. And you can sort of see where around where the phase 2 is going to start is after the April meeting, right? So I like that we're having these conversations because they're interesting and these are the important conversations. But this is the purpose of this document is for us to make sure that we know that at this meeting what we need to get done is we need to finish up identifying the tasks and subtopics and the domain frameworks and scales to be on a solid foundation for phase 1 before we move on to phase 2, which actually has to do more with the distribution of the survey and incentives. So thank you, Ted, for having this.
Okay, then that's not the last time we can talk about the survey and design and build and all those issues around it. But it is time for us to move to the next aspect of our meeting, which is the plan for the content outline. And you'll remember in the December meeting, we spent a fair amount of time talking about legal topics as content areas and performance domains as areas of responsibility that attorneys carry in their work. So the legal topics that make up the framework for the bar exam at present are shown in this slide. They are, we would call these content domains. These are the ones that are there presently. And you can see that it covers a broad practice framework. The current outline is all topically organized, and an alternative way of organizing, and I know the font on this is very small. I'm sorry about that, but the practice is around performance domains, and so practice management and administration, legal knowledge and skill, maintaining relationships and solving problems, and each of those areas can be broken down into more finite performance domains like practice management, case administration, supervision, collaboration, and then for legal knowledge, the activities of fact gathering, doing research, doing investigations, drafting and writing various documents, and then maintaining relationships and solving problems, being more specifically organized around client relationships, communication with various stakeholders, and then counseling, advising, both orally and in person and by phone, and negotiation and advocacy and resolution as an area of responsibility, and then court appearance. So last time we talked generally about how we could have content domains and performance domains. And we have come up with a plan where, and I know now you really can't read what's in all the little cells there, but the The idea here is that we can merge or blend content domains with performance domains. So what content pertains to what specific performance? Now I will tell you that the performance areas that we've listed, practice management and administration, and legal knowledge and skill, and maintaining relationships and solving problems, and the more specific ones underneath, are totally draft at this point. Totally draft. And while the content domains down the left side of this table are the current outline, it's up to this group to discuss the adequacy of this list, its currency, and if there might be a different expression for the topics that are listed there. But the thought is that we would blend the content domain framework with the performance domain framework so that we can link up and provide a context for the knowledge of in the different topic areas as it's applied through the performance areas. So I know that there's a lot of cells in this, and the font is very small, and I'm sorry about that. But you don't really need to read it right now. As long as you can understand what the framework looks like, you might be able to understand how it will work. When we break into groups in a little while, the group working with me in this room will evaluate the different domains and reach consensus on what they should be. And we'll move forward with those to educate the practice analysis panel when it meets 2 weeks from now about what they should start with and how they should organize their thought. I'm happy to answer questions, or if there's any need for discussion about this is a good time for that.
Can you give an example of what it means to start with one versus the other? Like sort of a concrete example, if you're starting with the content domains versus the skill area, what does it mean to start with one versus the other?
I'm not quite sure I understand the question.
Okay, so I think the question being posed to us or to the group is, what is the organizing principle for the survey, right? And there's 2 different options, as I understand it. Is that correct? Okay, can you describe again, sorry if I'm slow, but what are the 2 different options?
All right, so the thought is that rather than one coming before the other, they are both equal in the way that they work together in a blending framework. And so the outline, and I'm talking about the outline here rather than the survey. The content that is ultimately developed in 2 weeks will be the content of the survey. But this is just an organizing framework. And so the business association intersects with practice management and administration in that the skill in this cell here is determine reporting requirements and establish a budget, for instance. Those are just examples where in business associations under legal knowledge and skill, drafting and writing, is draft a demand letter where the topic is real property law. Then under fact gathering, research and investigation would be title, finance, physical attributes of property. So that's how real property intersects with the fact-gathering, research, and investigation responsibility. So again, I'm not sure that I understood your question. Have I answered it, or?
I don't think so, but I think it's okay. We can go on. If everybody else understands it, it's not an issue.
Yeah, no, we don't.
It's really how, so when I get the sense that there's an understanding of how to fill out this chart, but how does filling out this chart lead to the survey group developing the survey? How do the decisions that are made in filling out this chart affect what the survey ultimately looks like?
Stephen Furlow, could I maybe suggest something that I look at this? I mean, I like the way you're talking about it, Jim, and the interconnection. And I noticed that one of the things you've done here, going back to your previous slide where you had performance skills, is you had a column there which was to appearances in court. That's not here, and it shouldn't be here, okay? Because I was a practitioner for 20 years, I never appeared in court. And interestingly, we continue to believe that a majority of our lawyers and our graduates do. A school like San Diego, which is sort of about in the middle of the pack, it's a plurality, but it's not a majority. Okay, so what I like about this is I think, I look at the three essential performance categories, I think there are things that all lawyers have in common. Private sector, public sector, litigators, business people, people working in corporate, I think that really is good. I'm really comfortable with that. I think the challenge on your vertical column is, are we going to be comprehensive and add 12 more subjects to that? So I look at that and say, well, where's immigration and family law, right? Just to start, okay? Or are we going to narrow it down to a core that are more like the things on the top, which are common across what every lawyer, the foundation of every, and I think that's going to be the challenge, right? But I do like the way that you're interconnecting the two, and I think it's a very interesting framework.
I am firmly of the belief that less is more in terms of coming up with an outline like this. If we end up with 20 different content domains and 18 or 20 performance domains, the cells in this table will be so numerous that it's really unmanageable. I think people will understand more readily with few content domains and a reasonably small number of performance domains. And so I think it will be even more useful if we're able to achieve that. And so the content domains, deciding what they'll be is for the group that works with me in just a few minutes. And I think that if there are big buckets that we can drop these topics into, it'll be a big help.
To ask, was John the fellow whose plane got canceled?
Yes, that's my understanding.
Because he had very strong feelings and a lot to add on what's going to be happening next. I wonder if he knows that maybe Eli could call and let him know that he can participate by telephone for this next section. Have you, Eli, have you talked to John Palmer, because he really had a great deal to say before we break into groups. I don't want him to miss out on the opportunity to participate if he can.
Okay. Yeah, send me an email. I'm gonna double check with him right now. Move back and confirm.
Because he's welcome to call in, of course. I just want to make sure he knows that, because he brought a lot to the table at the last meeting. I don't want to miss out on it.
Yeah, I hate to say it, but so we didn't notice alternate locations for members of the working group to call in from. So if they're participating by phone, it really is to listen. They can only participate as a member of the public. So even if he calls in, he can't really do much other than make public comment. You could call for public comment during the breakout sessions. I suppose it could be structured that way, but just want to clarify, we do have to be Bagley-Keene compliant.
Sarah Cassidy. So before I ask my question, Donna, was your question answered? I know you asked something and we kind of moved on. I don't want to cut in front of you. Okay. So last time we were discussing basically what lens to look at the survey through, whether we were going to approach it from a content domain perspective or a performance domain perspective, and we struggled with that a lot last session. So have we decided at this point that we're going to do a blend, and at this point we're going to have a discussion? Okay, so
Yes.
If that's the case and we have decided that, I'm wondering if we're discussing content domains and if there's going to be a separate discussion of performance domains, or if that's kind of captured in the task examples.
There will be the group working with me in this room during the breakout session will determine the content domains and the performance domains. So that will be done, and it is there during the discussions that took place in your previous meeting in December. There was strong endorsement for both content and performance assessment, not assessment, but domain structure. And so that's the reason that we've decided to move forward with this blended approach. And this is a very well-established kind of framework in practice analysis. So we're on firm territory in moving forward with this arrangement.
And Sarah Cassidy, one more question. So you mentioned what the group that's going to be working with you is doing. Can you talk a little bit about what the other group is going to be doing?
Yes, they will be working on the scales that will be used in the survey. You might remember in the December meeting we had a handout with 7 or 8, 9 scales on it. And so that group will work with Dr. McInnes to determine which ones are useful. And one of the great things about the variety, because we're using 2 survey modalities and we'll have content domains and performance domains and tasks and subtopics and things like that, you can use different scales in different parts of the traditional survey. And so if a scale appears to be really useful for validating a content domain, then you should work it up for that purpose. If a different scale appears to be more useful for a performance area or for a task, then that is possible as well. So we don't have to use just one set of scales. We can mix and match according to how they best fit the content. And so it's not just the selection of those scales that group will work on, but also the wording of the scale itself and the different options for response, and so that those scale anchors are clearly understood and applicable in the most valid way to whatever is in front of the respondent at the time.
Jim, this is Hatem. We had also talked before, maybe in the breakout session for the scales discussion, possibly considering, a survey for new attorneys versus kind of one for those that supervise them. Are we going to still have that conversation possibly today?
My understanding of how we're going to differentiate the different ways that the outline might be applied by experience is to use the responses in the demographic survey to split the data so that we have the means of evaluating how different levels of experience, how differently different levels of experience will play out in validating the domains and tasks. I don't know how much time the group will need on working on the scales, but to the extent that, I think we want one survey for everybody. And that way we'll be able to compare responses. But and if we find that something that we've developed and through the survey is applicable to experienced attorneys and not applicable to entry-level attorneys, that tells us what the specifications for the test should be.
Ron B, again, confirming the discussions we had about the use of different scales in relation to the design of the survey, whether we send it out to every practicing attorney or for attorneys with different experience level, entry level versus those in supervising role to have different kind of a scale. Our consensus was that we should use statistical data to derive the kind of relationship based on demographics and other information so that based on the objective assessment from every participant, we have information to manipulate the data from different response groups. And that is the basis for our discussion about what's the best set of scales that we could use in order for us to capture all of those information. So just to wrap up all of the different topics related to the survey, if you think back from when we get the survey data, essentially we're trying to establish in practice attorneys what they are doing, using what set of knowledge and skills, and what's the characteristics of what they are doing and knowledges. So the set of characteristics or attributes related to those tasks in the two domains that's capturing those concrete tasks will give us the information to statistically establish the pattern, to identify the set of skills in terms of importance, competence level, all of those. So that's the larger design consideration to think about the survey sampling strategy and the deployment of different set of scales.
One of the major advantages of this approach with the survey is that sometimes surveys like this phrase the language of the question in the scale as what percentage of the time does an entry-level attorney or a newly licensed attorney spend doing this? Well, a newly licensed attorney can give a really good answer for that, but anybody else who's been practicing for longer than would be classified as entry-level or newly licensed would have to remember or make up some kind of answer for it. So the thought is that if we frame these scales to be, how much time do you in your practice spend working on this task or that, then we'll have valid information at all experience levels, and we can compare based on the demographics to see if there are differences in the ratings that they provided.
To stay on that point, I think one of John's points last meeting regarding the supervising attorney was that a new attorney doesn't necessarily know or understand if what they're doing is really important and that they should know and understand how to do it, or whether it's moderately or unimportant, whereas a supervising attorney could potentially provide more helpful information about what they believe a new attorney should be able to do or know. So I don't know if I think that's perhaps where the supervising attorney idea came into play. Are there scales that can be built to address that question or to do that cross comparison?
Can we identify supervising attorneys from the State Bar's database?
No, we don't have that information, although if it's absolutely necessary, it could be part of the survey question. The different approaches in tapping into that question, partly I think based on experience. Now, when we talk about attorney practice analysis experience, I can only refer to NCB's 2012 study. Their question was phrased to ask the respondents, assessing the frequency and importance in relation to entry-level attorneys, regardless of the year's experience of the responding attorneys. So that's a subjective assessment based on the way the questions are phrased. I think for us, given the potentially larger sample size, we should take advantage of getting more concrete, objective information so that we can use the different responses to identify patterns in the differences across all of those scales, rather than having one set of respondents commenting on the other set of respondents. I think typically that, at least in my own preference, that's a more reliable way of getting to these issues.
So Ron, I just want to make sure I'm understanding. Thank you. I think what you were saying is that the questions would ask the respondents, what are you doing? How much time do you spend doing that? When was the first time you had to do that?
How important it
how
is,
important
how
is it?
complex it is.
And so in response to what Jackie was saying, you're not saying that there would be a subset, a sort of repeat of those questions for those who are supervisors of entry-level attorneys to say, and in your estimation, can an entry-level lawyer do this? How important would it be for an entry-level lawyer? So we are still going to be having the entry-level lawyer's estimation of how important something is, how important it is that it be accurate, sort of whatever the scales are that we're looking at there. We'll have the veteran attorney's response for how important it is for them to do it accurately and how much time
David Chen.
And so there isn't necessarily
Has joined the conference.
between how important it is for them to do it and do it well than for the new attorney to do it and do it well.
Right, although just based on that single scale of importance, you might want to think about important in terms of a what in order to differentiate further what they mean by important, so that the more granular dimension under a particular scale we have, the better we'll be in a position to differentiate those experience level response rates or response patterns.
So
I'm sorry, but which breakout group is going to address this particular question? Because is there one of the two that's going to?
One is about the domains, performance domains, and organization and categorization of the two domains as the framework.
And one is about the scales.
So the scales. Yeah.
Because we had the conversation internally, which it sounds like we did not have prior to this meeting with the research team, about a different structure that I think really gets at your issue, Jackie, and I kind of have kept coming back to it, which is, does it make sense to actually ask the same questions of everybody? I keep coming to, no, it doesn't, because if I'm an experienced attorney and I'm being asked if I can do something independently, that doesn't really mean that a new attorney can or should. But I don't want to take so I don't know that issue is going to be discussed in either of the two breakouts. And I don't know if we want to talk about it at all. But I do think there is a question about the utility of asking everybody the same questions, regardless of their experience level.
Leah, it's Stephen Frillo. So I was thinking about that issue. And first, a preface. I'm going to say, why don't we look at how attorneys are evaluated currently by their employers, okay? And I just want to say, and I'll take a step back, if people have not read this article, this Chapter 7, this is terrific. I read it on the train this morning. I've already sent people in my office to sit down and read this. I thought this is really interesting in terms of what's going on in law schools, in terms of experiential, some of the obstacles and things like that. So lots of things. And I went into this thinking about content and thinking about, the metrics. And, the first part of it is all about what's going on in law schools where they're doing performance assessments, and all of that struck me, yeah. But then I got to the end of it, okay? And there's this section which talks about what law firms do. And that's the world in which I come from. And I've been on both sides of that. And they work, in other words, and here, they talk about these 4 levels. It's on page 136. This is what we all know as associates in these firms, and we all know as partners, are the levels of assessment. And we work within law firms from, and I assume the same thing happens in like the district attorney's office and city and all the other places. This is the framework from which we work, okay? This is what I expect as I'm developing as an associate, and this is what I as a partner expect of my associates as they develop. So there are ways in which employers look at these skills and how they develop over a period of time. And I would just suggest that might provide the basis for a common set of questions that would go to all the different lawyers who would address them. I'm sure they'll be identified in the survey. I'm a first-year associate or I'm a 20-year partner. They're going to answer from a different perspective, but they're going to work from the same. So if we could get to the same framework, I think it might be a lot more useful. But maybe we should look a little bit more, and maybe, Jim, you've already done this. You've have other things like this, levels of law firms, or ways in which legal employers, and it would be law firms, it would be public sector employers, it would be large, corporate legal departments, large nonprofits, how they evaluate what and so forth, because those institutions do that on a fairly regular basis. And I thought this was, and this one, which is in here on page 136, is completely consistent with my experience in 3 different law firms in terms of very, very similar metrics. Slight variations, but this is pretty typical of what's used in private law firms in my experience.
There's a lot on the floor right now, a lot of different questions and ideas. So I guess on the design of the survey, I'd like to, we're talking about the scales today and making some selections that ultimately will be beta tested. And the beta test results will tell us if we are heading in a good direction on how to capture the different perspectives that exist based on experience and setting and all those other points. It'll be a lot easier for us to have these conversations, I think, when we know what the content framework is going to be. Surveys can be built with branching capabilities. So if we put the demographic section of the survey first, depending on the responses that we get, we could assign different scales for more experienced people to use or present content that's different to them. I'm not sure that that's the right approach, though. I think that there will be questions that are more relevant to people depending on a variety of factors. And I'm concerned about predicting a priori what a person's response or interest will be when the point of the survey is to let them tell us. And so I don't really have an answer at this point for the issues that are on the floor. I think that we will be able to make intelligent decisions as we see what shape things finally are taking. Does that? I realize it's a cop-out.
This is Alan Steinbrecher. Let me just express something that I'm thinking about. I'm not sure whether it illuminates anything we're discussing as a group, but ultimately, the bar examination is a minimum competency examination to achieve a license to practice law. And so I think what we're trying to do with this survey is to understand what first-year, second-year young attorneys or relatively new attorneys are doing so that we understand what they need to know. And that is particularly acute in places where they have less structure than in a law firm. For instance, where in a law firm, third year, seventh year 20th year attorneys are all stacked up on top of each other to review the work product and make sure that, you know, a rabbit trail isn't pursued erroneously. There are a lot of attorneys who are much more on their own, and I think that's one of our primary concerns with the bar examination as we envision it, as I understand it. So I'm not I think we need to keep, at least I need to keep that in mind when we're designing the survey. We're trying to find out what's the minimum competence for people who are right out of law school, wherever they are, across a broad spectrum of practices.
I've been tempted to say this a couple of times this morning, so now I'm going to take the opportunity. We have a legal obligation to base the content framework of the bar exam on entry-level requirements. And we have to be able to document that. And so I think that's a big part of the reason that we are going to ask people to consider their own practice as they respond using the scales to the different elements of the survey. What we get for the responses of more experienced attorneys or more specialized attorneys in one way or another is useful information for other kinds of programming. But when it comes to the content framework that's decided on for the bar exam, we have to be able to document the trail that led to the decisions from the data that structures the content of that examination at that level. In a way, and that's the reason that the NCBE survey said consider the newly licensed attorney and how important is this to that level of practice. I think what we're doing yields a stronger basis even than that for determining what entry-level knowledge and skill will be, because we're asking people to what do you do, and rather than having them consider something that they might one time have been in their lives and evaluate it from that removed step. So I think we're building a stronger basis by organizing the survey as we are.
Could I just, Steve Allen, I have a question for you. I know a lot of people end up as sole practitioners, but I look at, again, my law school and 8 years of experience. Most of them start out as sole practitioners. And do we have the demographics of that? You know, I think that most people I know as sole practitioners started off in a public agency or in a smaller law firm with some amount of supervision. So I agree, a lot of people end up as sole practitioners or in very small firms where there's no supervision. But it would be really useful to know what the demographics of our profession look like in terms of how many people start out that way. Because in that case, there is no supervision. And that's sort of a separate issue. But what percentage of that, of the people who start out in legal practice in California, I think it would be useful, something useful to know in thinking about this. Because I take your point. If there are lots and lots of them, then it's another issue. Yeah.
This is Rambi. When we talk about minimum competence for entry-level attorneys, the question of solo practitioners often come up. And the follow-up question is how often, exactly the way you phrase it, how often do we have law student graduating and then getting a license and then enter into solo practice right away? Based on a 5-year survey from 2017, we asked a question about when you started out, what was the practice area or firm type? And it's less than, for first year employment, it's less than 5%. I don't recall it's 2 or 3%. When they started out in their legal career, they enter into a solo practice. Although that 1 year, we don't know whether immediately or after 6 months. So that percentage is very important. If the result shows, for example, 20% after getting licensed to enter into solo practice, obviously the the expectation of the competence will be very different if it's 3%. So empirically, we know, at least based on the recent survey results, which is fairly large and representative, it's not very common to enter into solo practice.
One of the things that we may get out of this study is to go back to a proposal that was made a few years ago about trying to get to more of an apprentice system in California, an apprentice requirement. I'd like to put that issue back on the table, frankly. I thought that was a good idea when it came up in that study a few years ago. But I think that's really important data. And then if you look at the size of the law firms in terms of level of supervision, but I take your point, Alan. I think that's something we really need to understand and be cognizant of. Thank you.
I'm the clock watcher in the group. I have to be responsible for making sure that every aspect on the agenda today has adequate time to achieve it. And so we're going to break into small groups, and the two small groups, one will stay working with me in this room, and the other group will work with Dr. McInnes, and the other on the selection and editing of the scales that we expect to use. I thank you for a really fun conversation this morning, and I guess Ron and Eli, how should we do the transition at this point?
Split it from here, this group going to one, and the remaining stay here? Just about equal number of working group members. We'll talk about scales in this group. From here, yeah. So it'll be 5. Yeah. Right. Everyone else. Would that work? They're equally fun, so don't.
Thanks very much. I'm staying.
So Ron, are we?
Alan, we're staying.
The first room. Yes.
Are we staying or are we moving?
You're staying.
Okay.
Emily Scivoletto, UCLA,
Domain.
has left the conference.
Just a note, if everybody can turn off their mics if you're leaving, and just turn them back on for when you're ready to speak. Thank you. Another note is that we're going to be having lunch here at 12. So the breakout groups are split up into before lunch and after lunch to continue the conversation. Thank you. Busy working in the kitchen.
But I didn't know if you wanted like the three of us. I think we should split up. Yeah. Are you gonna stay here? Yes. Okay, I'll go over there too. Okay, I'm in a food meeting. Yeah, I just thought we should be split up. Okay.
I want to go to the survey club, the scales. I'm going to stay here. I think Ron already called dibs. Scale. Sorry, Jim.
It's not like this one.
Sarah, are you in this room or are you in the other one? Okay, so we ended up with, I know, not enough people in this one. 3 plus Alan, so 4. You should have 6. 6 and 6, right?
I think some people might have went to the restroom or no.
Yeah.
4.
They're 4.
They're 4 and then.
Barula.
Steve.
Oh, yes. Okay, so it's that. Okay.
Steve's with us.
Yes.
Good.
Wanted to make sure we had sufficient numbers.
So we're waiting for Steve to come back from his journey. Eli, any word on how mad we are?
Oh, no words yet. You know, the words are coming. The building letter by letter.
They ought to be.
What are you guys talking about?
Tell you later.
Yeah.
Eli, you whet our appetite.
I think we're all back, and so we can begin. So we are, I would like for us to begin by focusing on the performance aspect of the domain framework. And so you can, as you can see with the color coding, we have just for the sake of example, practice management and administration, which can be divided out into practice management, case administration, and supervision, collaboration, and team. And then legal knowledge and skill divided out into fact gathering, research investigation, and drafting and writing, and so on. And as I said before, these domains that are presently in this table are just drafts. And so what I would like for us to do procedurally will be to begin with your own independent thought about it. So what I would like to ask is for you just on a sheet of paper near you to, if you yourself could decide what the performance domains are, what they would be. So just list them out. And what you want to do is to cover all aspects of lawyering with this. And but again, reminder, the a small number of buckets might communicate more than a large number of really discrete buckets. And so a domain is an area, a performance domain is an area of responsibility in the practice of attorneys. And we are interested in capturing initially your own view about it. So if you would list what, if it were left up to you as an individual, what would the performance domains be?
Are the ones that are on here, the draft ones, are these the ones that are the subjects of the current bar exam? Possible subjects to be tested?
The green column is currently there, but I'm going to hide that because I'd like you to focus. Those are the content domains, and so I want you to focus on, making sure that we end up with a good set of performance domains first.
So, Jim, are you asking us to identify this row, the legal knowledge and skills, or the row underneath it, fact gathering, research, investigation, drafting, and writing, or both?
I think both. If it's easier for you to think at the more finite level first, and then how to group them together if they are groupable, that would be fine.
So Jim, let me just understand. What is the importance of these performance domains? In other words, would work in one of these areas, let's just take as an example, establishing under case administration for establishing deadlines. That's something that's going to be tested on the bar examination ultimately, I assume. So what is the relevance of knowing this in terms of gathering information in the survey?
All right, so you'll recall that practice analysis is a giant job description.
Right.
And so this provides the context in which the knowledge areas are applied in practice.
Mm-hmm.
And so if you are researching precedents, what in say constitutional law, then it tells us, it allows us to understand what you need to know in order to do that proficiently. Am I answering your question?
Could I maybe try to get to your question in a slightly different way, Alan? It's Stephen Perula speaking. Aren't we looking both at the content of the bar exam and the form of the bar exam? It seems to me the two go hand in hand. And I look at these and say, if we see these as the performance skills, it gets also to the question of when we test these subjects, how we test those subjects, okay? Shouldn't we try to design an exam that helps, that tests the skills and the applications that our students need to have? I mean, you could say the easiest and cheapest way to do it is a 100% multiple choice test. I don't think any of us feel that's a good thing for lawyers. I think one of the mistakes we made in going from 3 days to 2 days is how far we cut back the performance test. And I'm hoping that one of the things that might come out of this study is we'll reconsider the balance between performance and other parts of the exam. So I see, so maybe I'm wrong, but I think there's a connection to both the form and the substance of the bar exam that we're really looking at and trying to inform.
Yeah, so absolutely. The job analysis study will sort of give us the basic information. We'll then take that information to do the content validation study. And the content validation study is not just looking at, do the questions test the appropriate subjects, but we'll also be looking at should we be doing more on research and writing and less on real property. So it'll be the format of the exam as well as the substance. So that will be the outcome of the survey, is now going back to the bar exam saying, now that we know what we know about this job description, what should the bar exam actually look like to make sure that we're getting to those things?
I think that's helpful because, I look up here and I see that a lot of these performance domains would be the same for almost all content domains. So you're going to have a lot of stuff in here. And I was trying to get in my mind, what do we really need? But maybe the answer is we just fill this thing out and then use it to winnow it down later as we prepare the survey and later iterations of our meetings and so forth. I don't know.
One of the big criticisms that we've heard about the bar exam, and maybe it sort of relates more to the millennial generation or just the way we do things now in the practice of law, is rote memorization may not be the skill that we need to test. And in parts of the exam, that's exactly what we're testing, right? The performance test that Dean Perula was referencing is something different because there you're given the library. And so we wanted to identify what are these performance skills, right? It's not rote memorization necessarily, but it's actually the ability to read and write. It's the ability to communicate orally with a client or a partner or a judge, or those are the important things that we need to train people on. We may conclude that those are more important than torts. And so we need to sort of weigh more heavily sort of those performance skills than the memorization of a particular subject matter. Okay. It may be that we find the exact opposite is true and exactly how we've been doing it makes sense and everybody loves rote memorization.
Yeah. Okay, that's helpful.
And I agree, especially with the comments of the dean, but just so that what we're doing now is looking at, we're going to be surveying what lawyers do, and then we're going to go from there. To me, this whole first section, the practice management and administration, could be eliminated. I'm not really sure if that, boy, I know some awfully disorganized folks that are excellent lawyers that would probably be deficient in all of these areas, but I don't think that's, to me, that's not something that we need to look at in this survey. I would rather the focus, again, be more limited so that we, less is more on how they're using their skills. To me, I look at the bar exam as an issue spotting, and that's so important to me. Can you get information and spot the issues as a lawyer, no matter what your job, public, private, academic, can you spot issues? Most questions on the bar exam, essay questions, have no right or wrong answer. It's can you identify the issues and explain your answer. So practice management, to me, I don't really see the relevance of that to the information that we want to gather to use for the next step. Maybe
And there's no expectation that these are real or final domain areas. These are there for the sake of example. And so I'd like to redirect the conversation at this point away from the bar exam and conversations around what it needs to look like and feel like, and instead ask you to, on a sheet of paper, without conversation, list what the performance domains would be in your ideal world. What should we include as major areas of responsibility for attorneys practicing in California? If you'll take a minute or two to list those, and I'm not going to give you a number that I have in mind. I don't have a number in mind, but if you'll take a minute to list those, then what we'll do is have you read your lists off. I'll record it all in one place so that we can see it on the screen, and we'll focus our discussion on that.
Mr. Harrison, Dr. Harrison, just one quick question to clarification about the bar exam versus the survey. The list that everybody's writing should be for what they might be doing at a certain point, for example, in the ESM survey as a category of actions of performance tasks, or are the ideal, when you're saying the ideal performance metrics in terms of what they'd ideally like to test for on the bar exam?
So the major areas of responsibility in the practice of law is what I'm after at this point. I'm not interested in the most granular level of detail yet at all. And I'm not even concerned about the surveys at this point.
Thank you.
Anybody need more time?
Has joined the conference.
All right. Who would like to be the first to read your list out? And as we do this, let me ask that we postpone conversation. So when you present your list, I don't want the rationale behind the items on your list. I just want the list. I'm going to, and we'll go around the room. And if you hear something that someone has said that you don't understand or you take issue with, sit on your hands, please, for a few minutes. This is not the time to discuss it. We will discuss them, but I need to get the database built first. So who will go first? Alan?
Alan Steinbrecher, I'll go first. I haven't deleted any of the domains that you have, I've added possibly two. The first I would call problem analysis or issue spotting. That to me is a key step in this process, no matter what the legal matter is, to understand exactly what the client's problem is and put a framework around what the work you're going to do is intellectually. The second is a client interview, which can be part of fact gathering, but to me, the client interview is also separate and important because it gives you the first real understanding of their issue and so forth and so on, as opposed to third-party fact gathering, which I would keep separate, but could be combined.
So did I understand you correctly that you are also proposing that the examples that are given are to be on the list?
Yes.
All right.
I mean, I think we could talk about it, but I wanted to add these two.
Okay. Yes.
I'm not suggesting that we take any of these off necessarily.
Okay. All right. And others may have different ideas about that, but we'll. So I'll go ahead and add them then. Legal knowledge and skill and maintaining relationships and solving problems. Okay. Thank you, Alan. Who's next?
Why not? Yeah, so I kind of wintered it down a little bit. So I'm a fact gathering, research, investigation, drafting and writing, communication with stakeholders, counsel and advice, and negotiation, advocacy, and resolution.
Okay, so I'm typing as you go here, and I'm not as fast as your secretary. So
Right,
I got fact gathering, research,
right.
and investigation.
Yeah, drafting and writing. Yeah, I'm basically was, as I understood it, two. Yeah, the two blue. Yeah. And
Well,
yeah.
All right, issue
I would say
spotting.
that,
Okay.
And then of three of the pinks. Communication with stakeholders. Counsel and advice. And negotiation and advocacy.
Okay.
okay. I also used your very illustrative draft ones here in mind, so and I eliminated the whole first section, but I am saying yes to the legal knowledge and skills section, and then the client relationship, which to me, Alan had the best idea, client interview. I include that in there. I'm skipping communication with stakeholders. Counsel/advice, yes. Negotiation, advocacy, resolution, yes. And court appearance, yes.
So negotiation, advocacy, and resolution is potentially different from what's already on the list. I know it looks like it's redundant, but I want the redundancy. For the moment, we'll take care of it. And so were you adding any above these?
No, but I did have court appearance, which I know David did not have. So court appearance is on my yes list.
It's on ours now.
Corporate attorney office.
Okay, and this is Robert Brody, by the way.
Okay.
Shanae Buffington. I think what you have looks good. I would not eliminate the practice management and administration category. I think that goes with workload management, as well as planning and organizing. So I would not, and when I say planning and organizing, I mean like determining your case strategy, so I would not eliminate that part at all. I think that's very important. What about a column for professionalism and civility working with opposing counsel on matters? I know sometimes we get a little snarky when we're trying to present our argument to opposing counsel, and there's kind of this back and forth. So being nice to each other, I think, is really important.
And so professional, what were your words? You said professionalism?
Civility. Professionalism, yeah. Yes, rather. And then are we going to get into the weeds about you know, like what we do individually as practitioners? Like, so I'm in hearings, so client interviewing, I would do that before my hearing. I would prep my witnesses as well as my auditor just about the facts of the case and what I expect to come out and when they testify, although that may not happen actually in the hearing. There are some surprises sometimes. So I don't know if that's...
So I don't want this group to get in the weeds at all. That's the work of the panel that is meeting in 2 weeks.
Okay.
And so what we want to do today is to come up with a set of performance domains that is broadly applicable. And then, you know, that group will test each one for different settings and specialties and all that.
So I guess the question is, the things that you just described fall under the categories that you just listed? And if not, do we need another category to ask them?
Like professionalism and civility, I don't see that falling under any of the categories.
No, I meant the things that you just described in terms of what you do in your
Oh,
does that fall under any of this?
Yes, Donna. Legal skills and knowledge, I would think. We're good?
Exactly.
Okay.
Exactly. All right. So then,
I like the what I call the three meta domains. I would order them. We had priorities, I might order them a little differently. What might get at your point is what I might call professional decision making, and that also comes out of this chapter 7, because there's this wonderful statement there that basically, which I think is the core of what lawyers need to do, which is make professional decisions in conditions of complexity and uncertainty. I mean, if you get to the heart of what we do, all lawyers do whatever we do. That's really what it is, and that will get to. I mean, the reason why I think that might be another meta domain is because I'm already looking at the column on the left-hand side saying that I would rather address professional responsibility not as a content subject, but as something that goes across both content and performance. Because if we just look at the rule, it's much broader than the rules of professional responsibility. It's what we want from lawyers is professional conduct in everything that they do. So somehow to capture that in the top, I think, would be useful. And maybe it's professional decision making, which is issues like yours. It is issues of civility, right? It's also complying with professional responsibility. It's also with, you know, a broader way of things to remind ourselves all the time that we're a profession and we have particular responsibility in a society where the rule of law is so important.
So I've added professional decision making and professional responsibility because it can be a performance domain, and if we're going to move it, this is the place to move it to. So that's really good. Did you have anything else?
No.
All right.
One of the things we do in our first year practicum, we start off each semester with a client interview. So in the fall, it's a tort case. You're interviewing your clients to find out how credible they are to rules. In the spring, it's transactional. You're interviewing your client to find out your client's objectives in getting the transaction. It's interview skills, but for a very different purpose, right? But whatever we do, whatever areas we practice, client interview is a really important thing. Understanding your client's objectives, understanding your client's case, understanding your client's objectives in the transaction is the same thing. And it's really critical. It's the first thing we do in our law school. And I think it's part of all of our.
Okay, so
the only thing that I
Don't worry about that right now.
Oral communication, right? So we've got it parsed out, communication experiences, but like if we're talking about writing, we also need oral communication. That's the only thing that I had that doesn't.
Okay, so then, everybody's given me your list?
Yes.
All right. I'm happy and amazed with the examples that we provided, living to see potentially another day. It's really good. What I'd say that we've got some suggestions for things that are new, but you also have one potential disagreement in the group, and that's around whether or not to keep practice management as a performance domain. And so I'd like to hear the reason that we should keep it first. Who would be willing to make a case for having practice management as one of the performance domains?
If I could, it's Stephen, if I could talk about that. When I go out and I talk to employers, and whether they be in the public or the private sector, this is one of the things that they're asking that we teach in law school. If you look at the NALP surveys about the qualities that they want in terms of the people that they employ, and again, across the public and the private sector, it's around issues of what we would call practice management. And if you look at law schools' curricula across the country, a lot of them are introducing this in the first year. I think that's, I don't know why you introduce it in the first year. I think it's a little bit too early on, because until you know what you're practicing, it's all hard to talk about managing it. So I would put it later in the year. But there is clearly, employers are saying this is something which is important. So I expect that it's something which is going to show up in our survey. So I do think it's a skill that employers are looking for, again, both public and private sector, because that's the feedback I'm constantly getting. And that's also what the surveys show when they ask for the qualities they're looking for in starting attorneys.
The case against?
I'm alone, right?
Yes.
So, you know what, I'm going to, I had my own feelings about this, but I'm very mindful of the feelings of my colleagues, and I think that they have swayed me. So I'm going to withdraw my, you know, your less is more idea, I think, really carries the day for me in much of what I do. And I thought if we want to really get our focus on what lawyers do, knowing that the next step is going to be looking at the bar exam through that lens, I thought this is certainly the least, when I'm all about issue spotting and things. But you know, given the well presented thoughts of my colleagues, I think I'll just I'll withdraw that so we can go forward.
So you know, that is the operational definition of consensus. I just want to, I feel like I've asked you individually what you think, but now obviously we have to think together as a group. And consensus does not necessarily mean total agreement or endorsement. It just means that you can live with the presence or absence of a particular word. And it sounds like we have consensus, to me, since the objection's been withdrawn, for practice management as one of the performance domains. Am I right?
So I'm looking at the case administration part of practice management specifically, and I think that's where a lot of the disciplinary complaints come from. And because of that, that's why I was thinking that it made sense, right? So this is you know, this is calendaring your deadlines. It's contacting your client with significant developments in the case. It's, you know, making sure that you are, you know, getting your fee agreements, and the sort of that part of that case administration, especially if you're a solo or from a small firm, I think is sort of critical.
Okay. So then the next example that is on the sheet, I'd like to get some decision about its legal knowledge and skill. And I'd like to hear the case for why that's a performance domain and not content. I think that the sub-examples, fact gathering, research, and investigation, that's performance. And drafting and writing is also performance. But legal knowledge is not performance. So is there a better heading that we could use for a performance domain that has fact gathering, research, investigation, drafting, and writing in it?
I'm not sure that I necessarily disagree. I mean, that I necessarily agree. Legal knowledge is essential to knowing what facts you need to gather and what research you need to do, and obviously the drafting and writing. So I don't know that it's inappropriate to have legal knowledge in that meta domain.
But wouldn't, and I'm just asking,
Yeah.
Wouldn't this green column be legal knowledge? Those are the content domains that are on the current exam. That this list looks to me a lot like legal knowledge.
Well, it is for those practice areas, I mean, those particular areas that are currently being tested on the bar exam. Going back to what Dean Ferrillo said earlier, it doesn't have anything to do with immigration or family law or anything like that.
I'm wondering, Jim, would you be more comfortable if the heading there was legal analysis and skills?
Yes, I would be much more comfortable with legal analysis than with legal knowledge.
Although I must say, because I think that might be the solution, but I have to tell, I think I might have said this last time, but I think about this a lot. So I went to law school when I was in my late 30s, okay? And one of the things that I learned when I went to law school is that I really shouldn't give advice on most areas of the law. And to me, that's legal knowledge, right? You know, that a little bit of knowledge is a dangerous thing, okay? That's not my area. You need to find an expert. And that's one of the, so, but I think legal analysis, that's a separate issue. To the extent I think about that, and one of the things that, the great knowledge that I have as a lawyer is knowing the things that I shouldn't be giving legal advice on and referring people to experts. But I think if we made that legal analysis, it might get around your concern.
It sounds, it will get around my concern. If do others in the group agree with the term legal analysis, or do you have a different suggestion?
I think that satisfies Alan's concerns and the Dean's kind of maybe a better label. If we're a little splitting hairs a little bit, but I think that that's as fine a label and maybe goes more to this domain than knowledge does. So yeah, I'm okay.
Yes.
Is there objection to making the change to legal analysis? Yeah, that's great. That's great. Okay, so then the next domain that we've put out for the sake of example was maintaining relationships and solving problems. And so I guess, I didn't hear any suggestion from anyone in the group when you were giving me your individual lists that you thought this one should go away. So I guess the question, my first question for you is maintaining relationships and solving problems going to stay on the table? I don't hear an objection. So silence means consent, right? Mm-hmm. So the point of this is to establish a right kind of client relationship, to communicate with various stakeholders clearly and truthfully and well, and counsel, advise, and negotiate advocacy and resolution. So the pieces of this are I think, probably clearer as performance areas. If the words maintaining relationships and solving problems don't do it for you, what words would?
I think what you're trying to get here is it's beyond, and because I struggled over this when I looked at it, right? And you're getting beyond relationships with clients. And it really gets to Shania's point of all the other relationships you need to have with opposing counsel, with members of your team, with the court, and people like that. And, that gets at your civility and how the relationships how you represent, say, your court or in a transaction affects how well you represent your client, all that kind of stuff. So I think that's what you're trying to encompass. And so it's not just so I think to narrow it to counseling, that focuses a little bit too much on the client. But I'm not sure how we, it's broader than the client, and I think it should be, but in a sense it's still focused on the client because ultimately our responsibility is to our client.
There's Robert Brody. I don't have a problem with the title as I think it's broad enough. I can't think off the top of my head of a better way to encapsulate that category. So I guess my vote would be that that's okay, unless well, that would be my vote.
I guess my question is it says solving problems, and I was just having a discussion with Judge Brody. Would that fall under legal knowledge and skills, or solving problems is that like a client control issue where you're trying to get your client to actually see what's going to happen if they don't take your advice, or I'm just trying to get an understanding on solving problems. What does that mean?
Solving problems is very broad, isn't it? Yeah, it is very broad.
Okay.
Yeah, I think that's right. I mean, I think you've got client relationship as one subheading, and you've got communication with various stakeholders. You've got client directly, but you've also got a lot of other people who are involved in most legal situations. You've got opposing counsel, you've got arbitrators, mediators, you've got insurers. If you've got a tort case, if you're a defense counsel, you've probably been retained by an insurance company to whom you owe certain duties, but you've got primary duty to your client, blah, blah, blah. So I think that these existing categories are useful.
Mm-hmm. Mm-hmm.
I'm intrigued by Shanae's question. Right, so the way I'm interpreting the question is really sort of the last two tasks under maintaining relationships and solving problems: counsel and advice, and negotiation, advocacy, and resolution. Do those belong here, or do those belong under legal analysis and skills? And does it matter?
It does matter, and we can certainly move things around. You have the authority today to do that. So at the end of the day, I'd like clear headings, and if there are subheadings, for them to be clear and in the right place.
Donna, in answer to your question, I think that actually counsel advice is different than legal knowledge in the sense that most legal problems evolve and over time, and they take on different aspects and incorporate different issues, and some issues drop off and some issues arise and so forth. So I think counseling and advice at the end of a case or 3/4 of the way into a deal may be different than the way you initially analyzed the existing problems at the beginning.
So where I completely agree with you, Alan and Stephen. Where I stumble a little bit, okay, on this is oral advocacy. So if you look at legal analysis and skills, we've got drafting and writing. That's written advocacy, but then there's oral advocacy. And again, I think whatever kind of law you practice, there's oral advocacy. And so that's where that's the one place where I stumble a little bit between these two.
So listening to you, I'm not hearing a suggestion for better language than maintaining relationships and solving problems. There's refinement in the detail that will come in the next step, and we can certainly add oral arguments or oral language, however we want to express that. But I'm not hearing disagreement or refinement in the language for maintaining relationships and solving problems. So I'm going to go ahead and mark it as green, and we'll keep it. This is not the last opportunity we have to decide about that, though. So, later on, if you have an epiphany about what the language might be, don't keep it a secret, please. Okay, so those were the three. We do have court appearance on there, and I don't want to get lost in that conversation just yet. I feel like I've heard over the past couple of weeks when we've been talking about these with several people by telephone that I've heard, pros and cons about court appearance. So if we can have that discussion probably right when we come back from the lunch break. Problem analysis and issue spotting is one of the suggestions that was made when I asked you to read off your individual lists. And so is that a category that stands alone, that was missing from the original examples, or is that something that might be embedded within one of them?
I agree that is super important to me. That is the most important. But I kind of, in my mind, I incorporate that into fact gathering, research, investigation. So I put it within there. So I don't think it needs a separate one. I think that covers it. But that would be my feeling. I suppose we could say issue spotting, comma, fact gathering, research, investigation, if we wanted to hit home that the very first thing in that process would be identifying the issues on which you need to gather facts and research and investigate. I guess that would be a suggestion to add those words.
So the thought is then, if we added problem analysis and issue spotting to fact gathering, research, and investigation, that would address it? Or should we add another column that might be first? Problem analysis and issue spotting seems like it would come before fact gathering, research, and investigation, right?
I would go as far as Robert does. I would just put issue spotting in there. I think that sort of covers it. That would be my view. But I do think issue spotting is absolutely critical. And we have the situation of a legal, and we get up above we have legal analysis and we have problem solving. So to me, that one way or another. But issue spotting is really it's very important to be there. I would agree with that.
Very good. You've helped us. So what we'll do then is add issue spotting to the first area on legal analysis. And are you satisfied with that, Alan? It was your suggestion.
Yeah, no, I think it could go either way. You could have a separate column, or you could include it in the heading here. I think it is important to have it flagged one way or the other. And I think it's just a matter of how many of these domains you want, as opposed to broader description of one domain.
And I'd like to go back to what Dean Ferrullo had raised.
and it was what was sort of included in my oral communication line too, is that the oral advocacy component of the legal analysis and skills separate and apart from the communication with stakeholders, from the maintaining clients and maintaining relationships and solving problems. So I guess I would pose the question of, is oral advocacy something that either can get lumped in with fact gathering, research, and investigation, or drafting and writing? Does it belong under legal analysis and skills, sort of in one of those columns or in a column all its own? Or is the group comfortable that it's covered under communication with various stakeholders under maintaining relationships?
Personally, I don't think it goes as well in that early kind of chronological blue meta domain. I think it probably comes later, but it maybe advocacy is already called out. And going back to the issue of, what I call problem analysis or issue spotting, if I were doing this, I might actually make a separate domain for that, because I think it is so important. It's so fundamental that I don't want it to be too washed in. But I also acknowledge the argument about trying to collapse some of this stuff so we don't have a huge menu of things we're looking at. So I'm not opposed to it. I just wanted to say that I do think it is so critical. I want to make sure that it gets good treatment in the survey itself.
So I heard two things in what you said. One concerning oral advocacy, and so and the other problem analysis. You're saying that we need to add oral advocacy as a separate area.
Oh, we have advocacy in that second from the right domain. So I think that means oral advocacy.
I see. Okay.
It can be written advocacy. But you can say oral or written advocacy. But I think we're getting into the kind of the weeds. I think advocacy covers it. That's the first thing. And the second thing, I just want to make sure that we do give significant weight to problem analysis / issue spotting, because it is so fundamental before you get launched into spending your client's money or wasting your time.
So I think we're all in agreement on that, because that I'm so glad that got brought up. But again, I say fewer columns yields a greater result, and I believe that if we add issue spotting to that first category under what is now called legal analysis and skills, that we will have covered that.
We're all good with that?
I have a comment, just in terms of, maybe I'm jumping ahead, but if I were to be clicking through this in a survey, I might get confused between having problem analysis under legal analysis and skills and having the language saying maintaining relationships and solving problems. If I were to be doing a task related to problem analysis, I might be inclined to go into the section about solving problems that actually is solving a different set of problems. So I might propose that we analyze whether or not we want to maintain this language of solving problems with maintaining relationships, or change that to something more specific.
Right.
And
there is potential.
I think we solved that problem, because I don't think we have problems under legal analysis. But I think, and I see your confusion. I would not put problems on the legal analysis. I think you got issue spotting there.
Yeah.
Problems are broader issues, okay? Yet, in terms of maintaining relationships, you have problems with your client paying. You have problems getting a response from the other side. All these things that lawyers have to do to effectively advocate for their clients. So I think I like that. I think when that's it's a broader set of issues than solving strict legal problems, right? I mean, a lot of in my experience, there are a lot of lawyers who can solve legal problems, but really don't do a good job serving their clients because it's all a matter of solving a legal problem. They don't understand that somehow you have to affect it in an effective and efficient way that yields what you're trying to yield. So I think that's what we're trying to get at. So I wouldn't change. I would leave that problems, I think, because I think it really is what a good lawyer has to do, whatever area that person's functioning and practicing in.
So it might be helpful for us to write a sentence or something to explain these buckets. We don't have to do that right now, but because of the potential for confusion, an explanation could steer some of that off to the side. All right. So then also suggested for us, I'm sorry, so client interview, and does that deserve a column on its own, or does it fit into one of the examples that we came with?
Well, it was my suggestion, and I think it fits within fact. I mean, you could certainly say client interviews, comma, fact gathering, or something like that.
Okay.
Or I'm happy to have it stand alone if somebody wants it that way, but I do think it's an important step.
And the interview would go, I mean, obviously, if you're interviewing, you're gathering information. I mean, that makes a lot of sense to me. And it's different there than communication with various stakeholders?
You know, just to put a more full observation on this, your interview with your client not only teases out what the legal issues are and kind of the background facts, you learn about 60% of what you're ever going to know about your case in that first interview, because the client is telling you what they're going to say in their deposition or at trial or whatever else. This is their position. It also tells you how much money they have to spend, what their risk tolerance is, you know, how long they want to stay in this, how fast they need an answer to the problem. I mean, is this going to be, you know, extraordinary TRO kind of relief or whatever, or is the deal going to go away if you don't get an offer in the next 30 days? There's a lot that goes into the client interview beyond strict legal understanding of the legal issue. So whether that's all important here or not, I don't know, but that's what motivated my thinking about the client interview.
Alan, I completely agree. Would it work to put it in that first column, in the first pink column, is to say client interviews and relationships? Would it work there? To call out interviews as well, because that's a critical part of the client relationship. And I would say that one of the critical issues in terms of client interviews is having those interviews and deciding not to take that person as a client, either because you have concerns about that client. Wonderful. Some of you may have heard some of the testimony this morning, by the way, or simply because you realize you can't serve the interests of that client because it's not in your area of knowledge expertise. You can't do it on the financial terms that make sense for that client, or all those sorts of things. So I think all the reasons you talk about, they're just so critical in terms of professional responsibility and everything else.
So that bucket then, that sub-bucket would be client interview and relationships or relationship.
The normal flow comes even before the legal knowledge and skills. So I don't know if you take client relationship. I mean, client relationship is an ongoing thing that kind of flows. I mean, it's in a logical place to be about client. But the client interview, to accomplish all of that going in kind of
Okay, so I heard one suggestion that we do it and one suggestion that we don't. I'm not a lawyer, so I don't have an opinion on this, and I need the group to reach consensus.
Well, I think Alan is 100% right. We definitely need it. The issue is it already encompassed in one of these? I just you know, I'm trying to be the least clunky in the number of categories, but I want to make sure that it's highlighted, because as soon as Alan said it, I wrote it down as, you know, the one thing that's missing. So, are you, Alan, are you saying putting it under client relationship, it needs to be before that, before fact gathering? I get it. In reality, it would be, of course, before you start doing your issue spotting, you're going to be meeting with your client. But I don't know if for purposes of this questionnaire, if it's okay to leave it there.
Yeah, I agree with you. I don't know. I mean, I think if I were preparing the perfect timeline, I would put it early on. Whether or not we can get the same results in our survey by including it in the client relationship, I'll leave that up to the
So if there is chronology, we should capture it. And there's value in capturing it. I think we're going to be sending this out to thousands of people who have not had the benefit of this discussion, and they're going to need to be able to track what you have produced here as comprehensive and reasonable. So with that advice, I would suggest that we locate it somewhere where it fits.
I agree. If that's important, in chronology is somewhat important. I think we should have it, whether we create a separate domain before fact gathering or include that task in fact gathering, call it out as separate.
So it could be client interview, fact gathering, research, and investigation.
And client gathering,
and issue spotting, right? Yes, thank you.
Gathering. So that's quite a mouthful.
That's quite a list.
Maybe it's just that to say client interview under legal knowledge and skills doesn't seem exactly right as a separate category.
How about if you divide it? I think you could break up research and investigation.
Oh.
That's something like that. If we started to divide that into the first part of the relationship, is the client interview, the issue spotting, the fact gathering. The next phase is the research and investigation.
That sounds like
that makes sense. And there may be some other things that we can go
through 3 instead of 2.
All right.
You still only have 3 columns. And in fact, I think most of those would be the heart.
So move the pink to be ahead of the blue. Would the pink be very first performance domain?
No, I think what he meant was just add one more blue.
One more blue.
One more blue, so the first of the 3 blues would be client interview, issue spotting, fact gathering. The second blue would be research and investigation, and the third blue would be drafting and writing. And then the rest, I think, are okay.
And that really is sequential.
That is exactly how you would do it.
Right, and I think that and it's not even one more column in the place that has the least column, which is the most, which is the foundation, really. So I think that would work.
Right, so let me, I know it's lunchtime, and I was kind of ready to take a cue from somebody else, right? I'm taking into your lunchtime. I just want to make sure I've got this right then. So we're adding a column to the blue area. It's client interview, issue spotting, and there was a third.
Fact gathering.
Fact gathering.
And so then the next column would be research and investigation.
Yep.
Okay, all right. I got it.
So Eli raised a question before that I want to, or raised a discussion point before that I want to sort of put back as a question and just make sure that everybody is sort of thinking about it that way as we're doing this. So the way I understood Eli's question is the way that this would feed into a survey instrument would be saying, hey, what are you working on now? And your choices are that very top grouping. So your choices are practice management and administration, legal analysis and skills, or maintaining relationships and solving problems. Those are your choices. And then if you pick if you pick maintaining relationship, I'm working on maintaining relationships and solving problems, then you'd get sort of these drop downs that say, okay, in what way are you doing that? Are you working on client relationship, communication with stakeholders, et cetera, et cetera? So one, sort of, is that a correct assumption? And two, if it is, I just want to make sure that everybody feels comfortable that I would know which one of those first levels to check to get to the answer that I'm looking for.
A little bit different. It's how important are these skills to you?
So
right?
both are actually important.
No.
In the experience sampling method that we're going to do, we're not asking for importance. We're just asking, what are you doing? What were you doing at 2:45?
We have to return to this question after
Right.
lunch.
Yeah,
It's
it
a
is.
long discussion.
Well,
yeah.
But in a sense, you're telling it because with the segmentation, if basically people say I'm not doing it right now at a lower level, then it's telling you.
Well, the follow-up question could be, right, so what are you doing if I'm doing drafting or writing? And then what they're talking about in the other room is scale. And how can we make that for
Yeah. So we're jamming up the works.
It's going well. I'm going to make sure discussions.
Yeah. So let's take the lunch break and we'll reconvene in half an hour. I'm very pleased.
Has left the conference.
David Chen.
Has left the conference.
Okay, we are back in session. This is the breakout group on content and performance domains, led by Dr. Jim Henderson.
And time is becoming a concern. We need to have this finished in 40 minutes. Now, quality is always more important than punctuality. So I don't want to leave any stone unturned, and I think it's enough time. But do keep in mind that time is limited. All right, so I have made the changes that we've decided so far on the big sheet, and I'll show you those in a few minutes. But looking over what's on the screen now, I think that everything that I'm seeing here in this first column has already been dealt with in our conversation before the lunch break. Am I incorrect about that? Just in the first column. You think I'm correct? I think I'm correct too. Okay, so then, in the second column, most of the things have been discussed and decided on, but it's much less settled. And so the area of court appearance strikes me as one that hasn't yet been decided. And I'd like just to hear a little conversation about whether it should be on the system and where.
Hadn't everyone mentioned that as one to be on? Be on the chart, court appearance.
This is Alan Steinbrecher. I think there was one comment about taking it off. I would be in favor of leaving it on.
I'm the one who's saying taking it off.
Oh.
The only time I've been in court was as a witness. Had nothing to do with being a lawyer. So, as I said, there's still this myth in a lot of places that most people end up being litigators and going to court. That is a plurality in our law school, but it is not a majority. And if you're a business transactional lawyer, the last thing you ever want to do is to be in court, because usually it's because you're a witness to something, not as a lawyer. Again, I think it works there. I mean, I think it's relevant to most areas of practice. But one of the questions that sort of gets to how much of the bar exam should be directed at litigators. And you sort of look at, that gets you a list of subjects of things like evidence and civil procedure. I'm not saying we need to take them off, but I don't know how you deal with that. I mean, any business lawyer you're going to write this to is going to say it's just not relevant at all. Most tax lawyers will tell you that. A lot of people who work with increased number of people work in-house and things like that. So I think that's the problem. It's assumption that we have general practitioners, all of whom go to court. And I don't think, again, maybe there's a study which tells us what percentage of the California lawyers do that. But it's certainly not all of them, and I doubt, and maybe it's half of them, but I don't think it's more.
I think this is Alan Steinbrecher. I think your point is well taken. I think it is a myth that all attorneys go to court. My hunch is it's much smaller than even 50%. My hunch is more like 20% spend any amount of time in court or in any kind of arbitration, mediation, any kind of dispute resolution. However, I do also, want to state the obvious. I think for those who are going into court and their clients, it's extremely important that there be a working knowledge of what to do and how to appear and all that kind of thing. So I think it's worthy keeping on. May not have the importance throughout the entire spectrum that some of these other things do, or the amount of time that are probably spent on real estate business associations and things like that.
So this would sort of get to the question. I mean, I agree that it should be there, and I like the way it's sort of placed there. It's not the mega. And then it would get to the question of how this would work in terms of a questionnaire, because I would assume that you'd ask the question, this would be a relevant question. You basically tell people, unless you're doing litigation, okay, those questions would be sort of, the questions on court appearance would sort of be irrelevant, right? But they're certainly important questions for those who are. And it's something you'd expect people to come out of law school with the ability to do if they're going to be doing that kind of stuff. So that gets to how this functions in terms of shaping the, you know.
Right. And the survey data will give guidance to the emphasis for the topic on the test. It, depending on approach, can decide it directly, or it can just give guidance to judgment about it. But that we include it here pretty much guarantees some emphasis on the test, but the amount of emphasis is a decision to be made months from now. So we're going to keep court appearance. Yeah.
But also just to go back to what the question you brought up and Donna's question before, so hopefully, I'm not sure where Donna went, but in terms of how this relates to the survey is that since we're going to be asking attorneys what they're working on, what they're doing, and there's so many different things that they can be doing, these domains help us locate the actual list of tasks, so you don't have hundreds and hundreds and hundreds of tasks. So it's not necessarily this is saying what's the most important or not, but how do we create a logical frameworks that is exhaustive, that includes everything. So I hope that clarifies that. Yeah.
I think that makes lots of sense.
Yeah, thank you.
Okay, so my belief then is it will leave court appearance where it is on the chart, and then the next question that I have has to do with oral advocacy. There was a suggestion that we have that we change the fourth column in the pink area from negotiation, advocacy, and resolution to negotiation, oral advocacy, and resolution. And so this is one of those instances where I'm fearful that by adding a word, we're actually limiting the meaning. And I wonder, so that's my question. Do we want the word oral added there?
I think I suggest that I would withdraw that suggestion for the exact reason that you articulate.
Okay.
Or could we say written or oral advocacy?
Yeah, you do that too.
Written
or
oral advocacy.
advocacy.
We can do that.
Mm-hmm. Either way. But I would agree it shouldn't be just oral advocacy.
I suppose, again, on my less is more, I'm okay with just advocacy with the idea that it encompasses both. I don't have a problem with saying written or oral, but I feel like just the category of advocacy is...
As long as it's clear to the survey takers. I mean,
That it includes
my only concern is would they see advocacy and be choosing between, or not thinking of written advocacy. Again, that's usually that'd be incorporated.
So I am going to add the word written and oral advocacy and resolution. Then the way it is written, and that way it leaves no doubt. All right. The next one that I think is out there, we've got planning and organizing. And I don't think that we placed that anywhere. Is that a practice management area? And is that part of case administration by any chance?
Determining the case strategy. Well, I'm looking under the column, the torch domain. It says develop a discovery plan and analyze discovery needs. I don't know if that encompasses case strategy or planning and organizing your case.
I feel like those things are incorporated safely into these categories that we have. I'm not sure if I would add a column for that. So I would say move on. I mean, I think those tasks are encompassed as they need to be, either in legal, well, in all areas here. Would be my.
So is there an objection to that?
See, one of the things I'm a little bit confused about here is I look at, I like the mega heading here, right? And then just because where would you put if you were going to put in those words that we just talked about, planning, organizing? It's interesting. You have the two sub columns here, and one is practice management, the other one is case administration. But then when you go to things below that, I think they sort of get a little bit confused. I think one of them is when you see practice management, it's not a case, it's all the things that you're doing. It's multiple cases or multiple transactions. The second one is the management of a specific case or a specific transaction. And the two columns are a little bit interchanged, right? So for example, if you take ethics, business, so you see what I'm saying? That might be where you want to slightly reorganize things you put under those two things, right? Because the challenges you face is you have multiple clients, you have multiple cases. That's practice management, okay? Case administration is the planning and the organizing of the, I think, so you see what I'm saying? I'm trying to draw that distinction between the collective and the individual matters you're handling.
Well, that kind of segues into the decision about some of the suggestions that Shanae made about professionalism and civility, professional responsibility, professional decision-making. So I mean, is practice management a professional responsibility? Is it a area within professional responsibility? If it is, we could move it out of, well, except for the whole first domain is practice management and administration. I don't know. What do we want to do with these things? And then we also still need to decide about planning and organizing. One thing that was said was that professional responsibility, which is in the green column as a content area on the current bar exam, could become a performance domain. And if it does, then it could encompass a lot of what we just listed.
Ms. Alan Steinberg, I think I'd be reluctant to take it out of the content. You may add it to performance, but it is tested, it is a subject matter in law school, it is something that people need to have some working knowledge of the actual rules of professional conduct. So I think I wouldn't take it out to put it in somewhere. I'd leave it in and then decide if there's another performance domain that we want to add.
So so are professionalism and civility and professional decision-making topics within professional responsibility as a content domain?
Well, there's some overlap, but
right.
Alan is right. That professional responsibility is two things. It is a codified thing that we test on the bar, and it encompasses overall the way you deal in your practice with your clients. So it's two things. Alan's right, because it is a subject that we test on with actual statutory. I think it needs to remain over there as long as we're testing on it. I feel like those other things are covered either by practice management or supervision.
Alan, I struggle with this because I think it was Shanae that made this suggestion. And professionalism and civility are so important and are being emphasized by the courts. It is something that we need to encourage and remind people of all the time. I don't know that I can articulate how to fit it in here, so I'm a little disturbed that I can't come up with a solution. I do understand the impetus of your suggestion, Shanae, and I think it's right. I'm just not sure how we would articulate it or ask about it. I think everybody would say, yeah, I'm being professional. I'm a very civil person, even though you're a murdering idiot, you know, kind of stuff.
I'm going to suggest
Can we stick it under the communication with various stakeholders? Is that appropriate, or?
So, I mean, one thing we might do is so that column now reads communication with various stakeholders. If we said professional communication with.
Well, no, not professional communication, because I know that will probably confuse.
That's more confusing, okay.
You know, maybe just put a comma after that and, you know, professionalism, I mean, or something like that. I mean, I think, I'm okay putting it there, but I think it should be at the mega level, because I think it's just so important. And if you get professionalism or professional decision-making or something like that, something other than professional responsibility, which is to avoid some confusion, something broader than that, I think would be a good idea, but I'd probably get up to the mega, right? Maybe it's maintaining professional relationships. Client and professional relationships.
But I don't want to mix apples and oranges. The survey is one thing, and what we want people to do and be mindful of, and what we're going to test on the bar exam is something else. So this is, what are you doing, right? Either 10 minutes ago or at all. So I'm not sure if this is, I don't know how you would, what you would say in this category. Are you being professional with your colleague? I mean, I think it's not a task. And isn't this questionnaire going to be more task-based?
It will have, yes, this part of the questionnaire will cover tasks. I mean, we expect them to be ethical 100% of the time. We expect them to be to treat others professionally 100% of the time. So for that reason, if we're keeping professional responsibility as a content domain, I think it sounds to me like a topic that fits there, because everything that's in professional responsibility we expect across the board 100% of the time.
I don't know if professional responsibility encompasses working with others in a civil manner. I don't know.
I agree that that is tantamount to any practicing lawyer, but I'm not sure if this survey is designed to either highlight that or solicit that, because that is something that you need to be doing at all times, whether you do even one thing on this chart, if you are licensed to practice law. But I think that's for another day, or maybe what comes next after we get this. Maybe we're going to ultimately change the bar exam to highlight that and maybe question someone on that to ensure that they are mindful of that. But I don't think that's this. Well, you're...
So, you know, I think it might be coming down to that conclusion, that it's so pervasive that there's not a single place for us to list it.
It's everything you... and to highlight it, and maybe that is where we're headed, that the very definition of minimum competence has to include that. But that's for another day. A day which you will control as our vendor, but not 2 days.
Okay, so for now then, it's an open question, but we think it pervasive, and we'll just leave things as they are. And so I think that correct me if I'm wrong, but I think we have discussed and made decisions about everything in that second column.
Can you tell me, was Donna right? What will it look like now that we've kind of honed? What does it look like when you open your email? What will it look like when you open your email? Just to get a sense of how does this play out?
Good question. And this is an answer that's subject to change as we develop the survey, of course. But from my experience using Qualtrics, which is what we're using for the ESM survey, is that you would click on one of these, what are you doing, which are the actual ones. Then you'd click on which sort of content you're working on. And in between, where you have the intersection of those two, there's going to be a list of different tasks that the panelists are going to have come up with that are going to be your options to select from in terms of what you're doing at that exact moment.
But what comes first, the subject content domain or our categories across the top?
So in the experience sampling method, it's going to be probably the not the high tier, but the next tier down in the domains.
Performance domains.
Yeah. And then there will be a scale or two on how important it might be, or when you learned to do that, or something, whatever they come up with next door. So there can be other scales.
I see.
So in the interest of time, I need us to focus on the green list. This is the current outline for the bar exam. And so, I haven't ever counted these. Are there 13 or 14?
13.
So are they discrete? They are, right? Except it looks like criminal law and criminal procedure.
Wills and trust is one subject on the bar exam if you're doing it by bar subjects. Is that how you made this list? What subjects do we test on the bar? Not all on each exam, but these are the topics from which we can choose. So wills and trusts is one topic when we're talking about what question will be on the next bar. My feeling is, given that the goal here ultimately is to give us another way to look at the bar exam, is we need to have all the categories at the least, and maybe at the most, that are on the exam. And maybe as a result of this survey, we may take some off. I don't know what we will do. But I think for now, yes, we need to have all the subjects that are on. Now, should we have more? Should we add family law and immigration, other areas of interest to our population in this state? That I don't know. What do you think? Put them in?
Yeah. You made that clear.
You asked the right question. I think, should you put the questions out there on the exam? I look at some of these and I start that. So obviously you put those across together. They are together. Somehow we break out remedies, but in virtually no one's mind, remedies a separate subject.
Right. Yeah.
And it's really, really archaic. It's just something. It's like 19th century. We need to get away from this. And the notion that we somehow people need to come up with a separate question related to remedies and teach as a separate subject makes absolutely no sense to me, either intellectually or practically. So, and someone said you combine criminal law and criminal procedure. I think. So I think that's the question. And I don't have the answer. Those are the questions that I ask.
And I think you can go, I'm for the least I want something that someone will do it. The best way to up the number, because everyone's going to get it, we have everyone's email just so everyone will get it. It's just, so I don't think there's going to be a question of anybody not getting it. The question is who wants to do it and who doesn't want to do it. So you can probably guide, what's the way to get the information and ensure that the most people will do it? Is it fewer categories here for ease on the eye? I don't know, the optics of.
Yeah, I mean, if we keep all 13 areas here and we ask questions of people with, say, 3 scales, then that, I mean, it's the number of clicks that discourage participation. Also, the more complex this table is, the more complex it's going to be to prepare the examination, assemble the test. There are more categories to check off, and it complicates things. If there are logical combinations or deletions that we can make, I think it makes sense to try to do that.
Let me make a suggestion along that line. Deviating slightly from the way the topics are just identified on the bar exam. Actually, community property almost is always involved with family law. So why don't we say family law and drop community property? Just substitute family law because it's more general. There are issues beyond community property that go into family law, but it will subsume community property. On constitutional law, I'm not sure that we need a separate category for constitutional law because very few attorneys work solely on constitutional issues. Constitutional issues come up in real property, they come up in all these other, well, not all, but many of these other areas. But I'm not sure that we're going to get much by constitutional law. I would call it criminal law and procedure and collapse those two. I would add employment law, which is very important in California, and I would combine trusts and wills. And frankly, I could leave out employment law, but I do think you get a lot of people who do a lot of employment law work. So those would be my suggestions.
Did you make a suggestion about remedies?
Taking out remedies?
Yeah, I'd take out remedies too. Thank you.
So I'm going to ask you another, I'm not telling you what I'm doing this. So if you said family law, okay, yeah, could that subsume wills and trusts?
No.
I asked that as a question. It's not a suggestion. I think it's worth putting on the table.
It's Alan Steinbrecher. I think for most people, although they are very related, oftentimes I do think that they're separate in in attorneys' minds. So I think it might be confusing if we didn't have wills and trusts.
Well, I also, and again, that's where I'm coming down as well. As also a situation we know that wills and trusts is one of those very archaic areas of the law. Right. But it's going to take real property. She's having the same issue about why we have this really archaic stuff, and it's really different because so much of the stuff that's existing in family law trust documents is really much more recent than statute. I'm with you on that. I just thought it was worth asking the question. But I like what you're proposing in terms of family law.
And how about if these are going to be areas that somebody is going to be clicking on because they're doing something in that area. Is that?
They're going to click on the performance domains.
So,
and these are content domains. So they may, after clicking on which performance domain they're working in at the given time, they may be asked, and what content were you relying on in doing that? So we can put these out there.
I mean, then we could almost take evidence out. I mean, although that is, a subject, I don't know if anyone is going to be saying I'm doing something, maybe in the context of a tort claim or a family law claim, but I don't think if we're going less is more, evidence in and of itself would not be something I don't think anyone would click on to say,
So the logical basis that I think you should make that decision on is not the survey, but practice. And if evidence stands on its own as a legal topic, then it should be on this list. But it seems to me possible that evidence would be a consideration in civil procedure, in family law, in criminal law, for sure. I mean, is it a standalone topic, or is it embedded?
Areas, well, Alan, you're running a huge law firm. We have quite a brain trust here between a law school dean and a law firm bigwig.
The system has detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm. If there is no response, the conference will end.
Should we be disappointed? I thought we were pretty entertaining, to tell you the truth.
So in my experience, in response to the discussion regarding evidence, in my experience, evidence is something, again, as a litigator, that you think of right at the beginning because it's fundamentally important whether you think you're going to be able to build a case around what you understand the evidence is going to be. And then you spend a lot of time gathering the evidence, and then you spend a lot of time briefing, motions in limine, or whatever, to get evidence in or keep evidence out. But it's really related to other different subject matter, content domains, as opposed to being something that kind of stands by itself. But you do have to have an understanding of the law of evidence, you know, the hearsay rule, and et cetera, et cetera. So I'm kind of on the fence about whether we could take it out or not for these purposes. But if we really want to be ruthless about getting these numbers down, I think we could take it out.
So, I think it's a really interesting discussion, and I think it's important. Again, I don't think anybody thinks of remedies anymore, so I would vote for taking remedies out, and I think some of the other suggestions. But, I'm going to look on both sides of the ledge. I'm going to look at evidence in corporations. All right. And I think there should be a category that asks questions about these things, because I think that's going to be useful. If you don't put evidence there, we're not going to find out that, I think, for a significant number of lawyers, evidence is completely and utterly irrelevant. And that'll be a useful thing to know. And as a business lawyer, put corporations in there as well, because I think this is helpful information. Because I think one of the issues that we face, and I'm talking about as educators and as practitioners, is we have this general bar exam in a world where legal practice is increasingly specialized. And so I would not be surprised if on a whole bunch of I don't think anybody's going, I think torts, there's some subjects that are the heart of what we do, okay? But I think for a number of these other subjects, I think we're likely to find out that for a number of them, that it's really a minority of people who really think that these are things that are valuable and things that they do. And that's going to tell us something about the specialization. And then it's going to pose the question of what we do about that. Right? So I would rather have evidence there, because I think you're going to get a lot of people who say that, I think you get some people who say evidence is really important to me because they're the ones doing litigation. There are a whole bunch of other people who are going to say it's completely irrelevant. And then we're going to have to figure out what to do about it. But if you don't put it there, I think we're not going to have that data. So the notion that I would be defending evidence, I mean, I have to say. It has to be to get me in real serious trouble.
Would you change business associations to corporations? No.
I would leave it.
I think business associations, yeah, business associations is the right, yeah.
How about one more block, other, and then a line, and you could fill something in if you wanted to?
In the survey, we will ask if, in a traditional survey, I don't know in the ESM if we would, but in the traditional survey, we will ask if any domains are missing and give them an opportunity to write it in.
So that's a good question. This is where the content sort of overlaps with sort of the demographic question of what practice area do you practice in. And so I would refer Jim to clarify that more, but Ron has been creating a working list of the different surveys and gathering first of all, the initial idea of what are all the different practice areas that a lawyer might be working in, and then gathering all the other, what they write in. Because generally we want to minimize the other, because then we can't analyze the data, because people are going to write it differently, right? So if we're getting a lot of data, we want to have an option for it. That's why we want these lists to be exhaustive. What I want to do is I wanted to go around and show people what a survey on Qualtrics has looked like, where we ask for practice area. Ms. Buffington, Dean Ferrul, I think you guys already filled this out on Qualtrics, but I'm not connected to the computer, but I'll show, I just want to pass it around just so people can glance at what many different content areas would look like. Sort of get a gauge of how many is too much or too little.
Right. I think I was disappointed, so I don't know. But I do want to see. Oh, that. Oh, let's see.
Yeah, that was.
Oh.
So the question here is, do we want to also include things like immigration or the construction? Are these the sort of things that, the types of law that somebody might be drawing on? Or do we want to abstract it a level above so that they don't see as many options?
I see. So you've got other on here, but oh, is this yours? It's so heavy. I think the conference call dropped.
But mind you, this is not for content, but this is for all the different practice areas. So, of course, if I'm in a practice area and we might ask them in the demographic survey, what type of law do you practice in? You can click on multiple options. But it might be interesting if certain types of law are used more and not necessarily just for people only in that practice area, if that makes sense. If you're a family lawyer, you're going to be working more with family law. But if we're serving an immigration lawyer and immigration law is not an option on here, then...
Welcome to Reservationless Plus conferencing. Enter your conference code, followed by the pound or hash sign.
And so that's a question I want to raise, is that if we have family law, because that was previously on the bar exam, is that sufficient? Or should we also be asking if we include the other types of law that relate generally to a type of practice as well? Does that make sense?
I think our catch-all is the other category, right? For all those other niche areas of law, specialized areas of law.
So that's one option, but this is what the conversation in the working group we hope to flesh out, and we can do other, but from the handing out the survey and analyzing the data perspective, it's kind of the what you don't want to do. Yeah.
Okay.
Yeah.
So yeah, but I mean there are going to be things that I think we don't put on here because in my mind we don't put immigration because we're not going to test for them on the California bar exam. They're federal topics, right? So I could see you filling in other because you are doing writing and drafting, but it's about a topic that we're not going to test for on the California bar exam.
But what I'm having trouble reconciling is this survey is a practice analysis. It's not the bar exam. So do we want to know exactly what areas our responders are practicing in without having to have a big trash can other category? Do we want to, because we're using this to take another look at the bar exam. I guess I shouldn't be so concerned about what's on the bar exam right now. I'm more concerned about we're starting all over. That's the direction of the legislature, that we need to look again at our Supreme Court. So if we want to do that, maybe we should have other areas in which people do practice law in this state and see how they use the skills that they have in their areas. Maybe that's where we need to go. I mean, is
And
that?
but I think that's the distinction, right? So, and let's look at it two ends. I mean, let's take the immigration law issue, because I tend to think the immigration law issue where I think there's an argument that we might need more and let's look at the other end, okay, in terms of what's vital to the economy of California. I'm going to say tax and intellectual property, okay? So I'm not at all suggesting we put tax and intellectual property here on the left-hand column, but I assume that when we do the survey, people will identify themselves as tax lawyers or intellectual property lawyers. And they're going to tell us which of these foundational courses is valuable to them. Because isn't that what we're trying to do? Because, again, I don't think we're ever going to test on intellectual property or tax because they are more federal issues and things like that. They're a level of specialization. But it's going to be useful for us to know from those lawyers which one of these foundational courses are important to them to make some decisions. So I'm hoping what we do is that as far as testing, we narrow down to a core. So people then, when they're in law school, in terms of what they need to do for the exam, they're narrowing to a core, and then to the extent they need to specialize, or if they're going to be generalists, they sort of make that they sort of be able to make that choice. So I think that's the distinction. You want, when I fill out the survey, I want to identify the fact that I'm a corporate securities lawyer. Again, you put securities law. I don't expect you to do that. Okay, so then I can fill out with these subjects and say which one of these is valuable to my practice if I'm an associate or whatever level I'm at. Right? Are we on the same page on that?
I don't know we were asking that question though.
But I thought that
We do need to be clear on exactly what I thought that we were asking what people do and what skills they use when they're doing it. Right. So I want to know IP. I want to know all. I mean, I guess I want 50 categories, right, of all the areas of law, just like the chart on Eli's iPad. I want that, or do I not want that? I mean, that seems like if we have things on the bar that are not relevant, let's see what is everybody doing. I guess what is everybody doing, and then from there decide what are the best subjects for appropriate issue spotting to establish minimum competence. Like your iPad thing has what, 25, 30 different categories of practice areas. So hardly anyone would put other there, right? You've included everything.
But I'm going to ask a question. I mean, let's take a step back. So what if we do this survey and more people tell us that they're practicing tax than tell us that they're practicing wills and trusts? Is that going to be directional in terms of we're going to add tax to the bar exam? That's what I.
Well,
and
I think the answer. I don't know. Yeah.
I think the answer is ready, lawyers. Yeah. It depends. But yeah, I mean, it may be that it means we don't need to test wills and trusts, or we can test it sort of with less frequency. It may mean that we need to test tax. It may mean that regardless of how many people are doing tax, we still don't think we need to test tax. But most people are doing tax, and in doing tax, you need to be really good at this performance domain. And so maybe we need to test that performance domain more so. So it's sort of a mix of everything. So yeah, we're definitely going to want to know the others. The question is, do we want to list them or have them do the free form on that? It feels overwhelming to list 25.
To list all the possible practice areas, but I think I as the representative on this committee from the Committee of Bar Examiners, I think everything is on the table. I mean, they are willing to scrap the entire bar exam and start again with something that is more relevant if that's what's appropriate. And
or that what we're doing with the bar exam is proper, but we've tested it to the outer limits, and we can now say with greater confidence that the existing bar exam is perfect or somewhere in between. Yeah.
Correct.
So I'm kind of coming around to the more is less point of view. And maybe we should have, let's call it Eli's list. And with one, other opportunity. Because I've taken a lot of these exams, or these surveys, excuse me, and it really doesn't take long to look through and say, oh, I'm doing admiralty or whatever it is, So I'm not sure that that's going to be a real hindrance on the survey.
What do you think as our survey maker? If you saw Eli's list, it's like Schindler's List, but for the practice of law. If you saw that page as a component of the first steps, does that trouble you as
No. And so I think that if we are asking someone first what performance domain they're working on at 245, and then ask them what content area they were drawing on from that, we'd better give them a comprehensive list of content areas. They will frustrate them if they were working on text and we didn't have it on the list. So I guess time being what it is, I'd like to draw this to a close. And I guess, so I've made notes in the conversation. So I'm a corporation. I'm not a contractor. I assume it's going to be a question. People follow the subject and say, what extent do I use admin? That's what I'm. Right. So once we've collected the data and analyzed it, then human beings with brains will review it and make decisions about the design of the test. And so I think, just because we put immigration law on the list, on Eli's list, doesn't mean that we have to test immigration law on the state bar exam.
And to add to that, thank you, Dr. Harrison, is that for the NCBE study from 2012, they also broke it down into content areas. And what they asked and this is for a traditional survey, because in the traditional survey, they just had a note saying, answer this if it applies to you. And so if you are a business lawyer and you don't do immigration law, you don't answer that part of those survey skills, right? And the way it would work in the ESM method is that you would write, oh, I'm working on drafting and writing, or I'm interviewing a client. And it's happened that the client was dealing with, was a criminal law client. And so then you would go into criminal law and procedure, right? Yeah.
So I guess the last, I guess my big question at this point is, we're going to substitute Eli's list for the green list here. Is that correct?
That's my vote. I think that Dean is right. I mean, if I was filling this out, my area, labor and employment, not on here. So I might just say, oh, I'm not doing this, because none of these apply to me, or administrative law. None of the things I do are on that list. So, and I want you to have me fill it out. So I want to be inclusive in the green, and maybe, our funnel is going to be big at the top and then narrow as we go down. I like Eli's list.
So some important notes about my list, and that it's comprehensive in terms of practice area, but it doesn't include some of these content domains that we have pre-existing, including evidence. It does not have, I'll list them out because these are just 13 or 14, so there's not many. It does not have evidence, contracts. It does not have professional responsibility. It does not have any of the procedures. So do you think it'd be helpful to combine these pre-existing ones from the green and combine it with the list of the practice areas to have a comprehensive list? Sinead's telling me no.
No, from my understanding, I just thought that when persons open the survey, they'd be able to check their practice area. I didn't know that we were proposing to integrate the practice areas with the content domain. But that, am I confused or?
So you're talking about two different, first they identify their practice area and then they choose from this.
Well, they're not choosing from this list, are they? They're not choosing from the green, from the content domains and subdomains, right?
So in the survey, I guess they'll get Eli's list, but in I'm a bit confused myself. I feel like the conversation on the survey is driving more than it should. Actually, I think that we need to maximize fidelity to practice, and I don't know which route or combination of the two is the best way to get there. I'd imagine that if you've got 13 legal topics that are covered on the bar exam now, and you double that, there's going to be some fallout.
And I think that a lot of the confusion is that in the pre-existing list of subdomains, you have areas that are practice areas as well as areas that are knowledge areas. So evidence and procedure and responsibility are knowledge areas, whereas family law and criminal law, those are practice areas, if I'm not mistaken. And so whether or not we have both of those or have a combination of the two, because as it stands right now, it's a combination of the two. And if we do have practice areas, is it all right to only have a select practice areas that already exist on the bar exam instead of comprehensive?
I think I want to take back what I said earlier about let's at least have the subjects that are on the bar exam, because I don't want our current bar exam to drive anything that we're doing today. We are looking afresh at practice areas, and then we will apply that to the bar exam. So for purposes of this survey, I don't want to be bound by what's currently on our test. I mean, we may find that's exactly where we need to be, but I want to be looking at these survey results with fresh eyes.
Yes, but well, what I'm yes, I think it's important to know what practice areas people are working in. But it seems to me that there is these certain number of content areas that are taught in law school and tested on the bar exam are also kind of fundamental building blocks that cut across a number of the different practice areas. And I'm not sure in my own mind how we get the results that we need from both of those at the same time. So I guess my first question in trying to sort this out is, are the two surveys that are going out, the one, the ping instantaneous survey, and the other, the emailed, survey monkey or whatever it is, survey, are they going to be exact duplicates of each other?
No.
Okay, so we're coming up with something that's going to be adaptable for both.
And I think that, my job is to validate with the traditional survey the content framework for the test. And that's performance domains and content domains. So I'm thinking we probably need two lists. One for the experience sampling method survey, that's Eli's list, and then one to validate for relevance to be tested. And that would be this list of, or some modification of it. People do not practice.
Right.
So I think we should stick with the list, be like practice. I assume that when the survey is here, okay, if I identify myself, any area I'm in, okay, what, across the board, every area you can think of, advocacy law, corporate law, so some sort of a question, I'm not, you know how to would be, do you write a review contract? Is that important what you do? I assume there's some question that's going to be along those lines, right? Do you refer to the evidence? I mean, isn't that the way we're going to get those subjects? That's the work of the panel to develop, and it will be part of the. Well, it seems to me then to say it's a practice analysis. This is where I'm struggling. I'm where you are. These are the building blocks. One of these I become convinced about. That's the building block that makes us. Okay, we can't throw those building blocks away. At the same time, this is a practice analysis. We got to start there, and then the next layer is how important each of these building blocks is. It just seems to be the practice that takes practice. And then we get these building blocks. Questions that we ask across the board. We ask every single lawyer in California about the use of contract. I think that's what we have to do. So then do we need to build in into the because I'm not. How do you do that? Right. Yeah. I don't know. I don't know that we're getting right. If there might be one for the other.
How do you do that?
Get there, right? That's the challenge.
Right.
Yeah,
so who needs to know it? I mean, that's right. So I can offer a suggestion about evidence so these content domains can have subdomains. If the content domain is criminal law and procedure, evidence could be a subtopic there. If the content domain is civil procedure, evidence could be a subtopic, and so on. So some of the things that are on the list now might apply broadly under other topics. And if that's the case, then we can trust that to the panel to work out. And before we conduct the survey, we'll bring it back to the working group.
But just to be the wet blanket, in litigation, you can have a subject matter area of any of these. You can have real property issue. You can have civil business associations, employment, whatever it is, torts, obviously, wills and trust. You can litigate any of these content domains. So in any of those, you would have to have evidence of a procedure, whatever else, advocacy, and so forth. So I see rocks and shoals ahead in our progress trying to incorporate all this. But I think we're inching towards some kind of solution, but I just want to raise the flag that there's so much overlap here that I'm not sure how it's going to end up. Eli?
Yeah, I think that it's really productive and interesting discussion. I think Dr. Harrison's approach could work with it needs coordination, but we are mixing two different things in content areas and knowledge areas that in the knowledge areas could apply to almost all of the content areas. So it might make sense to have a layered approach, like what Jim was saying. And the question when we have a layered approach is, do we ask the knowledge areas first where it's talking about, or do we ask the practice areas first? And we hypothetically could we could have it that for every single of the practice areas, it would break into the knowledge areas in terms of if you're doing litigation, correct me if I'm wrong, or could be criminal or civil. Litigation right now is not its own topic, correct? Or it's not its own content?
I would propose striking court appearance and putting litigation practice there on this sheet that we have.
Is that broader than court appearance litigation practice?
Yeah, I would think so. For litigation practice, I think we could even stick the interviewing clients and witnesses under that column, as well as preparing for the case for trial.
And it would be litigation practice rather than just the word litigation.
Well, that area. I mean, we could. Well, litigation or litigation practice versus court appearance.
Is litigation as a word? Is that to people performance or content?
It's in this column here, which I believe is the performance column.
Yeah.
Wherever court appearance is court appearance its own performance domain, or does it fall under maintaining relationships and solving problems? Because it's a different color, so.
When I added a column, litigation went off on its own over there, so I've got some word processing to work through.
Well, but her idea was to replace court appearance with the word litigation.
Litigation, right.
So
and I've made a note of that. I just don't have access to it in my word
Oh.
file.
Oh,
right now.
I think that's.
Since you guys scrapped my professional responsibility idea.
And you scrap my no law.
So deposition.
But, so I have a question. Would it make sense that after every of the content domain, there's a subdomain? So if you were to go into wills and trusts, there would be contracts, procedure, evidence in those knowledge fields. Or if you were to go to immigration, it would have those three. And you could choose neither. You could choose one. You could choose multiple for these.
I think that's too.
I'm confused.
I
really am.
You know, not everybody's going to be an Eli Wallach. There's going to be some less sophisticated. I think that's too much.
Too much.
But I do still like the Eli's list as the. But I'm sorry, I want to make sure, stepping back, they're going to do that anyway? They're going to be doing Eli's list before they get to this screen?
So, no, we haven't built the surveys yet, so we're looking for your guidance. But I would say that Eli's list is more useful for the ESM survey than it is for the traditional survey. Because I don't think we want to validate 26 legal topics for the bar exam. With the experience survey, we're looking really at, what they're using right now or what they are doing right now. Both of those two things. I think that the topic list for the test, though, can be different and maybe should be different. But, I mean, there are a couple of ways to go about this. One would be to survey Eli's list. And then as part of the analysis process, synthesize that list into a more reasonable number of content areas. That's a possibility. I don't know. Let me summarize what I...
This one was, so we went out, we surveyed then we asked, here are the current subjects. Right? One is very important. Use what some scale. Okay? And then ask those people, say, what other subjects? What's the area? Is that what you really want?
Well,
I mean, that's what I don't understand.
I think that at the end of the day, we're trying to validate the topics for the bar exam, the content framework for the bar exam. And I think it's fair game to ask, to present the list and ask them to rank order it or to, express some importance that that topic has to their practice. I think the question in my mind is whether we have one list that we're trying to work with or two. And I think it's fine to have two, but I think in having two lists, we need to recognize that one is practice area and the other is content area. And Eli's list is practice areas. And so having a content list, I think, is a different thing. And we've been, I think, wallowing around trying to mix the two notions, and they're not the same thing. So I don't know quite where we're ending up on this. I would suggest, since we needed to have ended this conversation 25 minutes ago, that we probably aren't going to come to clear resolution on this now. The panel will, and I think that we need to kind of live with where we are now and trust it to the panel, and then see what they produce and how the logic that they followed fits with what we need, and move forward from that. I need to make sure that my notes on this sheet are correct. So on court appearance, we're changing to litigation, and as sample activities, it's going to be deposition, discovery, and stuff like that. And then on the content list, I think I heard consensus that we're changing community property to family law. I think we're combining criminal law and procedure. I think we're combining trusts and wills. I have made notes about employment law. Are we adding employment law as one of the topics?
That was my suggestion, but I think not anymore. I think since we're more clearly differentiating between practice areas on the one hand and content domains on the other, I think we can eliminate employment law. I think in the content domains, we need to look at this list that we have and focus on the really fundamental building blocks that we teach in law school and that we currently test on the bar exam, because I think to a large degree that'll be what we will continue to be important in licensing. Yes, I think so.
I'd already crossed it off my list. Yeah. So there are also then other legal topics that came up in the conversation earlier. Some of these I think are federal, and so we wouldn't include them on the list, but I want to verify that. Intellectual property.
That's a practice area.
It's a practice area. Okay, so I'm not going to include it here. Immigration is federal.
It's also a practice area. You could put it on just if you want the information, but it's not a California fundamental testing area or knowledge area. Let's put it that way.
Tax. Same.
Which?
Tax.
Same.
And what about labor law?
The same as employment law.
Oh, yes, of course.
They're different, but they fall in the same category. They're not fundamental knowledge areas that you have to practice law coming out of law school.
Okay. So then what we have on the list are business associations, civil procedure, family law, constitutional law, contracts, criminal law and procedure. What about evidence?
I think we should keep it on. Yeah.
Okay, evidence, professional responsibility, real property, torts, trusts, and wills.
Yes.
Okay, all right. Thank you.
We have appellate, business, construction, criminal, disability rights, elder abuse, employment, media and entertainment, environment, estate planning, family law, healthcare, immigration, insolvency, insurance, intellectual property, juvenile delinquency, juvenile dependency, labor relations, legal malpractice, military law and veterans, personal injury, probate, real estate, taxation, and workers' compensation, workers' comp. I think that's a good point. Because we can this no matter what, this is actually a question that's going to be asked on the demographic part of the survey as well. So that is something we want to be as comprehensive as possible. The only place there's overlap now is the practice areas that exist on here and on the content areas are in criminal and family law. Those are the only two places where they overlap, and there might be good reason for them to overlap in those two areas.
I'm searching for a description of a lot of plaintiffs' work that it, yeah. Or, you know, we have securities class actions. I mean, wage and hour, that's employment, that's already covered, but properties, consumer fraud. Yeah, yeah.
And so something
more general than personal injury in the tort area or in the plaintiff's area. Yeah, tortious claims. Maybe that would be something.
This is helpful. Thank you. I'm taking notes, and it's good because this part, all of the demographic surveys that we run, is changing to accommodate what people write in for other and these sort of suggestions. So it's helpful. We're not sure. I would assume we put names.
We're going to know who they are, whether it's a name or an access code or some other numeric identifier. Right. We need to be able to follow up with them and stuff like that, so we will know who they are.
For clarification, and this is since we've come to a pretty good point on this domains, correct, Dr. Anderson? So I don't want to take up time if we're pressed right now, but the demographic survey for the traditional and the ESM is going to come for the traditional, it's going to come with the survey. For the demographic survey for the ESM, it's sort of there's going to be a separate survey that's sent to you, and you fill it out with your demographics, and then you'll get your pings. And in your pings, you're not going to have to refill out the demographics that you put in before. That means that most people, if we were to have the practice areas in the ESM survey, it might be repetitive. It would only be catching if they were working using knowledge of a different practice area in their own practice, or if they were working on multiple practice areas, it would be helpful for us to pinpoint exactly what they were working on.
And the only other two areas that come to mind, and I'm not sure you need to add them, but just for your thought, is water and admiralty.
And so just to wrap it up, when I work with the panel 2 weeks from now, I'm going to present the performance domains that you decided on and the content domains that you decided on as a fait accompli. If anybody has real heartache about it, they'll speak up and they may suggest a revision. But we're going to start with the idea that this working committee has put these lists together and believes that they're the ones that we ought to run with. So we're good with that? And we want them to finish their assignment. So they've got a lot of work ahead of them. I really appreciate it, folks. You did a beautiful job. Yes. It was, an interesting thing to finally realize that you're doing practice areas and we're doing content domains.
Yeah, it was confusing because the one on bed and the bar exam, they don't allow trying to clarify which one's which.
Kind of interesting.
We're now on a short break. We expect to reconvene in about 5 to 10 minutes.
Your call cannot be completed as dialed. Please consult your directory and call again, or ask your operator for assistance. This is a recording. Welcome to Reservationless Plus conferencing. Enter your conference code, followed by the pound or hash sign. Thank you. If you are the leader, press star now. Please enter your leader PIN, followed by pound. To start or join your conference, press 1. To change, you will now be placed into conference. After joining the call, to record the conference for those who may miss this call, or for future playback, press star 2.
Like the environment? I will sweat it. Let me send out several emails.
We don't have our leader, but I'm inclined to, oh, here he comes. Yes, sir.
Okay, we are beginning again, and we now have the entire working group reassembled, the two subcommittees that broke out over the last couple of hours to look at a couple of different areas here. And I'm now going to turn it back over to Jim to start his report.
Thank you. The group on the performance domains and practice and content domains had some really lively discussion. The area of practice management and administration, if you have that big, if you can see on the screens, was left intact. The next area that was in the blue columns was legal knowledge and skills when we started out, and that became legal analysis. And we added a first domain in there, calling it client interview, issue spotting, fact gathering. And then some of those things we took out of the next column, which is now simply research and investigation, and then drafting and writing. The next area was maintaining relationships and solving problems, and we talked about that name as a heading for a while and decided to live with it. So then the first subdomain area in that is interviews and client relationship. And then the others are intact. And then the column heading court appearance became litigation. And that will include depositions and discoveries and things like that as tasks. On the content domain side, so we added a column, which is going to be interesting. But on the content domain side, we actually pared the list down a bit by combining topics that go together and substituting broader topics for some of these. So I'll just read the list. The original list was in alphabetical order. My list is not yet in alphabetical order, but we'll figure that out. So it's business associations, civil procedure, and the community property became family law. And then there's constitutional law, contracts, and then we're combining the next two, criminal law and procedure, as one area. And then evidence, professional responsibility, and we intend for professional responsibility to include the notion of civility, professional communication and civility. And then, of course, it covers other areas as well, ethics primarily, but other areas as well. And then there's real property. We have deleted remedies. There's torts and trusts and wills as a combined category. So we moved from 13 on the list down to some smaller number. I haven't counted. It's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 topics that we have at present. Did I get that right? If you 14 to 11, then. Okay. So that was a lot of discussion, a lot of fun. I'd like to thank the group.
So if you like, we give copies. We can also email you an updated copy of the new version, but this is the original.
Yeah. Yeah.
Old, yeah.
Yeah.
Thank you for asking.
Am I able to project? I think that would be helpful. I'd have to use HDMI, so it's probably not going to work. Okay, well, I'll just read to you then. I would like to project this, but I don't have the ability at the moment. So we focused on the rating scales, and you should have in your folders, you should have some of these in your folders if you want to follow along there. The group recommended a frequency scale as the #1 scale. It will be used they recommend it for the traditional sampling method only, because in the experience sampling method, we will be able to gather that frequency information from the data itself. Asking the question, on average, how frequently did you perform this activity in your practice during the past 12 months? And combining that with the other frequency scale to develop a scale from never to repeatedly. So if you have those, you can follow along. The #2 recommended scale is a criticality scale for use with both sampling methods. That one remained unchanged from what you may have in your documentation. It reads, what degree of harm may result if an attorney is not proficient in a domain or task? Harm may be legal, financial, psychological, or emotional. The third sampling method, sampling question, or survey question, was about performance expectations for use with both sampling methods. The question being, when were you first expected to perform the task? With a list of months from 0 to 12 or beyond 12. So trying to capture what happens in that first year of licensure. And then a fourth survey question taps into the complexity or higher order ability, which we felt was best to pilot on the experience sampling method survey during the beta test, because there was a little bit of confusion about how it may be received. But the question is, what cognitive activity does a proficient attorney perform when working in the domain or task? And that goes from recall to understanding, application, and analysis. The group also made a number of recommendations for other scales, but we were not able to formally finalize those. So just some recommendations to consider as we move closer.
We have 8 minutes, and so I can't really invite many questions about the work that the subgroups did. Certainly, if there was something that you didn't understand, we'd be happy after the meeting to talk about that, or in the next meeting. But I want to thank you for a really productive day today, and for your how well you listened, how thoroughly you understood, and how hard you worked to achieve the progress that we made. So with that, I'll turn it back over to Alan. I understand that there's to be an update on the panel selection process.
Yes, and I just have one question for, I guess, all three of you. We've put a lot of work here in today, and we are moving towards, I think, defining, how this is going to roll out and so forth. But obviously, you will be doing work between now and our next meeting, and so I assume that there is consensus on the working group that we are going to delegate some discretion to you as you move to preparing for the panel and then on to make some changes to what we have recommended today, if necessary. And I don't know what the boundaries or what the guidelines are on that, but it wanted to make sure that we're aware that you have some degree of flexibility in translating what we have done today into a usable work product. Is that your understanding?
Thank you for that clarification, and it's possible that we would need to make some kind of a change, but we'll be transparent about that. We'll bring back to you what we did and why.
Okay.
Can I ask you a question?
Sure.
So will the panel be considering both the domain task work product from today and the scaling work product from today? And will they be able to make adjustments, or they're simply going to go to the next step and develop the actual survey questions?
So the panel is largely going to flesh out the detail within the structure that we've created in the content framework with performance domains and content domains. The scales are more a matter of survey building that if there is time in that meeting, I'm happy to let them try them out. I would really love, if there is time, to use the scales with them as an alpha test to make sure that they fit the way that we've built this before we even do the beta test. But I don't think that they're going to need to, if they have the opportunity totally to rewrite, then, we needn't have had the conversations today. So I'm hopeful that what we'll do is inform them and then let them pick up with the more detailed work.
So maybe my question is for you, Josh. How do you envision? I mean, we left some things hanging with the scales. How do you envision resolving those issues?
Well, the primary things we left hanging with the scales were potential additions to the experience sampling method survey. I don't think we left too much out there in terms of the traditional survey because we have 3 scales, which will likely be quite a bit to take the survey respondents quite a bit of time to answer those questions. So, moving forward, I plan to pass along the notes that I took to Jim if he's able to work some of that into the panel meeting, or it may just be a discussion that we have with the bar about whether or not we feel that the additional survey questions are necessary or if they make sense.
I think we'll go back and focus specifically on one of the dimensions that we're able to resolve, which is scales related to difficulty, complexity, and memorization. So I think overall they tap into a similar kind of a construct of memorization being often the topic of the bar exam. So we need to go back and then try to come up with a scale that would work to characterize the degree of memorization in performing certain tasks, and then to see whether that scale would work for most of the questions in the survey. And we'll certainly, by the time of the panel meeting, we'll have that scale in some form to review with the panel members so that we can finalize it.
Okay, we now have an update on panel recruitment and the upcoming meeting from Eli and Ron.
I'm just asking to get the computers plugged in for a little PowerPoint presentation, but in the interim, I just want to say if everybody can see the process and timeline sheet that's in your packets, or it was also attached to the agenda from this morning, everybody deserves a pat on the back because we were able to really move forward today with a lot of the work that's going on in phase 1. And I think that we've left it pretty prepared for the panel, such that by the next working group meeting, there's going to be a draft beta survey for you to review if all goes well in the panel. But that's the goal, is for the next working group to have the beta survey, and then for us after the next working group to deploy the beta survey, which is going to test out these scales and questions. And then we're going to meet again in June for us to discuss as a working group the results of the beta survey and how to adjust for the actual survey deployment in August and September. So everybody, pat on the back. It's a long project, a long study, and it's very big. And I think that everybody today has been really impressed with how we've been able to bring it down and create actionable results. Now, we're almost there. So, as you guys may have seen in my email correspondences, we had a survey for applications to partake in our panel. And if you missed those correspondences, please contact me separately. Particularly if you missed those correspondences and you wanted to partake in the panel. But we had a very successful, I would say, application process. We used Qualtrics, which we're going to use for the actual ESM survey. and Ron, feel free to interject at any moment here. But right when we get the, and thank you, Dr. Harrison. So here is, if you look at the first slide, we go to the next slide. Yeah, so the panel, one of the questions that we asked was which dates would be better for the panelists, whether it be during the weekend or during the week. Pretty overwhelmingly of our 23 applicants, all except for 4 indicated that they'd be willing to, they would be available and willing over the weekend. And so that was the large majority. And so from the 23, we asked questions about practice area, firm size, sector, as well as demographic questions, as well as years of experience. And we had a really diverse pool of applicants that I'm going to show you in the preceding slides, but we were able to select 15, and from those 15, 13 have already confirmed their attendance. And so we were aiming for 12 to 15 panelists, and this is pretty perfect. So this was good, and it was a pretty short turnaround as well. So could we go to the next slide real fast? Yeah. Oh, can we go to the next slide again? Oh, wait, go back to the last slide. Apologies. Yeah, so this is, again, what I said, the application questions. I got confused myself with the format. These are the questions that we asked. In terms of sector, it was asking between academia, private sector, public government, or nonprofit sector. In terms of organization and size, we asked sort of different for depending on which sector. For example, in private sector, you could have a solo practitioner, but for government and whatnot, we started out with 2 to 5, and then 5 to 10 had different categories there. Years of experience, similar. We're looking for people with, I believe, over 5 years of experience. So we have, or over 3 years of experience. So we have 3 to 5, 5 to 10, and then 10 years and more. And so can we go to the next slide? Yeah, and so if we look at sector, these are sort of the breakdown of the sector. I put an asterisk on academia because in academia, almost everybody from that who responded with that sector has previous private sector experience. And so this is not overlap, this is just where people are at pretty currently. But we also reviewed their resumes and whatnot. And so that's the sector breakdown, and the next slide is going to be all the different practice areas that people put down in terms of where they are. And so as you can see, it's a pretty comprehensive list of practice areas that people put down to be represented on the panel, which is great because we want as diverse practice areas and from all things as we can to make sure that our list of questions is exhaustive. And so can we go to the next slide? And one of the last before the demographics is the experience breakdown. And there was, just in terms of the pool of 23 respondents, there wasn't too much variation, but a lot of people responded had over 10 years of experience, and they're represented a lot on the panel, as well as a portion of it is 6 to 10 years of experience. Then the next is demographics. As you can see, it's pretty nicely split between male and female, and between race and ethnicity. There's a large representation of different groups. I think that's a success of the bar's outreach, so I think that's a good thing. And yeah, these are all the sort of breakdown of how the panel is going to look in terms of practice area size and demographics. And I really welcome any questions or any comments or any further points. And if you don't think of them now, you guys always are welcome to reach out to me and ask a question.
Ron, anything on this topic from you?
You got it covered
Okay.
all.
All right, great.
I just want to add, if you're interested in observing the panel, which is next Friday, you're welcome to spend a day or too. Just looking at how the panels go through the long list of the task. That's the key part of this project.
Thank you, Jim.
And I note that two members of the working group, Dean Furlow and Shanae Buffington, are on the panel as well. So thanks for the double duty, and appreciate it, and be interested to hear what you have to say when you get back from that experience. I am going to attend Friday mornings and Friday early afternoons sessions, so I'll also have some insight, but I'm going to leave before the real work gets started. All right.
Thank you.
Our final topic before we wrap up, or next steps and wrap up. Ron?
Next step is actually just the next week. We're going to prepare all the materials to get ready for the three-day panel discussions, and the results of the three-day panel work would create material for the consultant to take back, and then going through their editorial process to potentially modify some of the items or reorganize them to fit it into the survey structure, and then start doing the pilot test. And we're going to need some participants, volunteer participants, to help us pilot test the beta version of the two surveys, especially the experience sampling. I think this part is critical because experience sampling survey is something that has not been used in job practice analysis setting. We put a lot of hope on that to give us more rigorous information to compare with the results from the traditional survey. So we'll reach out probably later on to ask you to help nominate some volunteers for the beta testing of the survey.
And are you looking for volunteers from the working group or from outside the working group?
From both, because we're looking at 30 to 50 volunteers to help us pilot test the two surveys.
I think we can reach out to CLA, the California Lawyers Association, and the, I forgot what it's called, the Young Lawyers section. I think that'd be a great group to reach out to for a pilot or beta, alpha, beta, whatever, testing. Yeah.
All right. Are there any other questions or comments? Yes.
Just wanted to say I found the reading materials that you sent us before today's meeting to be helpful, and I had a request for the next time if you send us information. I think it would be helpful to me to get a little bit information on the current demographics of the bar. Just who are we currently? It gives me, to help me give me some background information. I know Ron mentioned today that about 5% are solos, and it'd be nice to kind of get a bigger picture of the practice currently.
Thank you. I'll note that and send that out.
Thank you.
Anything else? We run the risk of actually adjourning early. I know that's sad news for you all.
Yeah.
But I'll go out on a limb and no.
Yeah.
Okay.
I still
All
think
right.
we still have 20 minutes, but I need to make some time to give some administrative announcements, updates, and things to do for follow-up, just to keep everything running. And so thank you, everybody. I'm happy that everybody's made it here. There's a lot of storms going on, and so we actually missed some working group members, and it's unfortunate, but I'm happy for the people who was able to show up and had a good day. The expense reports for San Francisco, it was only lodging and food, as well as, it was only transportation and food, including parking, and the hotel was covered. This time in LA, you're going to have to put down the hotel as well, and the hotel fees. And so if you were not able to get a receipt from the hotel, let me know, and so I can take note of that. But there is a logistical difference between San Francisco and LA. For all future meetings, it's only going to be transportation and food. Just for this meeting, please note that the lodging needs to be expensed post facto. Yeah, and I'm happy to answer further questions on that, but it's just a matter of adding it to this expense report, which I will email out to everybody this week with the follow-up and notes from this meeting, as well as these materials of where we got with the survey scales, domains, and any other sort of requested documents. It will also include the digital version of the expense report, but I also have a paper version in your folders. So everybody should have a paper version. Please get this to me in the coming week, 2 weeks. I believe that there's a sort of 6-week deadline or for getting these processed. So, yeah.
The hotel was not double paid.
The hotel was not double paid. There, so yeah, there's going to be expense, but you'll be expensed. So.
Okay, just one other small administrative note, and I think we talked about this a little bit earlier, but just to come back, obviously, it's much better to have everybody in person at these meetings, but if for some reason you're not going to be able to attend in person, you're certainly welcome to attend by telephone. However, if you do, you need to give us plenty of notice. How much? 10 days notice, is it?
Right, we need to include the location that you're going to call in from on the noticed agenda, and the noticed agenda has to be published at least 10 days in advance.
And that place has to be ADA compliant. So if you're calling from your home, theoretically, you could have some member of the public show up to attend the meeting, and your home would have to be accessible and so forth, and you may not want the public in your home. So those are all things that we just have to consider under Bagley-Keene, unfortunately. Okay, so I encourage you all to be in person as you are. Thank you very much. And unless there's any other questions or comment, yeah, Eli, my go-to guy.
Yeah, I mean, just giving me ideas with what you're talking about. And so, last thing for people to take note, I'll add it to the meeting email as well. Next meeting date, April 24th, a Wednesday. The meeting day after that, June 19th, Wednesday. We'll add that to the email, but just so people could, have it, once, twice, 3 times in their notes, and nobody will forget.
Which cities on those 2 dates?
So the next one will be in the April meeting, will be in San Francisco, and the June meeting will be here in LA.
All right. See if I can do it this time. Any other questions or comments? You excluded, Eli? Okay. Thanks very much, everybody. Bye.
There's some confusion in the way that the bar interacts with hotels in San Francisco and LA. San Francisco, we have a pre-existing relationship with the hotel. I guess in LA, we specify something different to get it paid for. So I know